May I please, your lordship? Item number 9, my lord.
Yes.
My senior is out of station, my lord. As in for the day, my lord.
When counsel for the petition is circulated, an adjournment slip list after 4 weeks.
My lord.
May it please your lordship. Lordship,
Yes.
I beg to mention item number 13 and 14 of the day.
Yes. Why adjournment? Why do you want adjournment?
Lordship, we're seeking some few weeks' time to receive instructions.
The matter pending since 2022. What more instructions are required, madam?
Some few weeks' time may be given.
And counsel for the private parties. So and so. Submit that she needs some time to complete her instructions list after 2 weeks as brief.
Lordship, what the interim order is continuing.
Yes.
Interim order passed in writ appeal number 295/22 shall continue. Shall remain in currency till disposal of the writ appeal. Will confirm.
18 to 26. May it please your lordship. Lordship, I beg to mention item number 20, your lordship.
Yes.
I'm making this mention on behalf of Mr. S. Chetia, your lordship. Lordship, the learned counsel is not well, your lordship. Therefore, the matter may be adjourned for the
My lord,
day.
the judgment awaited by Supreme Court has been delivered. That is actually in favor of SSC, my lord.
Okay. That
So it may come up next week, my lord.
search 153A. No,
Yes.
that's the
My
judgment.
lord. No incriminating materials.
No incriminating material.
My lord.
All right, it's stated that standing counsel, Mr. Chetia, is not well. List on 2nd August.
My lord.
No. Oh, 2nd.
Deeply okay.
May I please your lordship, I beg to mention 18, 19 and 21. My senior Mr. S.P. sir got injured on Tuesday. Kindly,
How is he doing now?
he is recovering.
He is recovering, so he'll come back in the next week.
Yes, lordship.
All right, Mr. KL, it is stated that standing counsel, Mr. KL, is not well. A request is made to adjourn the matter. List on 2nd August. All right.
Lordship, can it be after 2 weeks, lordship, 18 and 19? Lordship?
2 weeks. All right, list after 2 weeks, 18, 19. And 21 also at 2 weeks then. All right.
Lord, I'm seeking your lordship indulgence, Lord, as regard item 25, Lord.
There are hardly 25 cases and you want to get 1/3 of the list adjourned.
Lord, what happened, Lord, we were subsequently implemented State Election Commission, Lord.
Yes.
Lord, we are required to file our affidavit, Lord. Lord, I was seeking 2 weeks time, Lord, in this.
When were you implemented, sir?
On 20 April 2023.
All right, and counsel, Mr. Sancho, naam likhiyega. Appearing for the State Election
Yes,
Commission.
Lord, respondent 9.
Respondent number 9. Praise for it is granted. 3 weeks time to complete his instructions. List after 3 weeks.
Deeply obliged.
May I please your lordship? Lordship, I beg to mention for listing lordship.
What matter?
One WA lordship, matter relating to non-payment of salary lordship.
Is it a new matter?
Yes, lordship.
All right, get it listed whenever you want. Yes,
My lord, this matter may be listed for admission, my lord, on Monday, my lord.
fresh matter,
No, my lord,
Then?
pending. My lord,
pending matter. What is the next date fix, madam?
next, notice was issued in the month of 22nd of February, returnable by 4 weeks, but.
It has never been
No,
listed
my
back.
lord.
Find out and get it listed then. All right.
Item 1.
Yes, any progress, Mr. Nath?
Malada, the PWD person, they went there. They have already earmarked the alignment. But there is a difficulty as regard one portion, just starting at the starting of the road. That particular landowner, he is not accommodating, he is not allowing the person to, in fact, demarcate also.
Why?
No, according to him, he said that he has no notice of this proceeding.
It's a private land.
It's a private patta land.
The private land, Mr. Chaudhary was representing.
A major portion we have considered.
Okay.
Now from the map which PWD has prepared, it appears, my lord, a portion of the private land which would be required for maintaining the alignment I think they have, the aspect has been shown. So my lord, if it is the correct position, then there are two options. My
Either to acquire,
Either acquire
to
or
change alignment,
my lord, High Court
slightly change alignment.
assigns, change the alignment, or High Court may kindly think of, I mean, giving up some land from the other side. Is that it?
There is I'm told that there is a wall of High Court. If that is, some portion is just given from that side. That can-
In the starting point,
Yes,
near
yes,
the
yes.
High Court.
Yes,
At the starting point from M0.
it's about 6-7 feet, not more than.
But according to them, they said the entire land will be 40 square meter,
31, 31,
41,
31,
around, or
31 square meter.
three lessons of land.
So if the High Court gives up that land, then you can realign the
Yes,
route accordingly.
yes.
That is one of the option, Lord.
Then that let Building and Infrastructure Committee take a call,
Yes.
that is
because
this person,
acquisition would again take a long time.
Correct, correct.
if the state go for acquisition, this road will never
Will
be
never,
a reality.
never come up, yes. So
So
we'll-
only
we'll
way
request in the building, all right, Mr. Nath submits that,
But I have
Appreciating the position.
then let's see.
I have a small.
there is a office note, flag A and B, registry is notice there.
Hmm.
There also the map.
The first point, my lord, that the starting point, that's the land.
So this private plot,
First one, yes, my, that is coming into being.
or we reduce this towards Uzan Bazaar, the High Court's land, a little bit of land can be taken.
It's about 6-7 feet. not-
I think we think
Demarcation to alignment to মিলাই আমি বাকিখিনি হৈ গ'ল খালি তলৰ portion ওলাব পাৰি কিয়? মেপত যোনটো পৰিমাণ আছে ৰাস্তাটো ওলাইছে সেই মাটিখিনি তেওঁ নহয় হা।
But it's a private.
Logic, well, can I send the PWD person today so that they can go and see that, let them measure well, how much land from the
all
High
right,
Court
so
side?
Mr. Nath submit that
Firstly, if I may submit, Milord, whatever the land is available, that has to be measured by with the help of the revenue department, has to be demarcated. Then a requirement is to be, Milord, placed.
we'll
How
give.
much land is
Mr.
required? At
Nath
length,
has
Milord.
submits that a fresh snag has come up in executing the working plan, because a private party, there is a private land at the beginning of the road, and the owner thereof is resisting and objecting to the realigned part of the road in question. He urges that if High Court agrees to give up a part of its land to towards the west side of the road, this bottleneck can be removed and the road can be constructed. In view of the facts noted above, we hereby direct the engineer concerned of PWD along with the officers of the Revenue Department, to undertake a fresh measurement and present an exact map with both the alternatives, suggesting
Only that disputed portion.
map in conformity with the revenue record, strictly in conformity with the revenue record. The measurements so made shall be reflected in a newly prepared map with all possible alternatives.
80% already they have earmarked, Lord. Only the left out portion, otherwise the rest portion they will not do.
Only at the start of the road.
Mr. Nath, in the event of proper measurement being made, maybe the private person might be found encroaching on government land.
Exactly.
So let the actual measurement be done at this spot.
According to our information, the land belongs to somebody else. Anyway.
Let's not go into that complication. We want the project to be completed.
Yes.
Yes,
The report shall be submitted for the court's perusal on 1st August.
first of all.
First of all, is Tuesday, Logic.
Yes, it will take hardly 2 hours.
Yes.
What?
Logic.
Deeply yours.
Item number 2.
Pros and cons. Let us think of it. Yes,
May I beg your lordship? Lordship, this IS for continuation of delay of 80 days, lordship.
the issue notice to the respondents. Standing counsel MS Bora appears for, madam, you will be appearing for
2, 3, 4, 5.
2, 3, 4 and 5. Deputy SGI, Mr. RKD Chaudhary puts in appearance on behalf of respondent number 1. What do you say to delay? Madam, any objection on continuation?
In case of delay, no.
MS Boda and MS Chaudhary do not object. This interlocutory application has been moved, seeking condonation of delay of 80 days occasion in filing of the connected writ appeal. MS Bora and Ms. Chaudhary do not object to the delay being condoned. बुला लेना एक और चौधरी साहब. Thus, the application is allowed. Otherwise, also, we have gone through the grounds set out in the application and find the reasons assigned therein for explaining the delay of 80 days to be germane. Hence, the application is allowed. Delay is condoned. Connected writ appeal shall be numbered and listed for admission. Same order in next case. Same. 81 days.
Tag with WA,
They are tagged.
with WA, 44.
Is that ration card matters? All right. But first, we'll have to admit the petitions. Let the appeals come up for admission first. Three also.
Item number 4.
1 day's delay.
Lordship, there is delay of 1 day, my lord.
But there are private parties, we suppose.
1 person, my lord.
So you'll have to get them served.
Lordship.
Issue notice of the interlocutory application of the respondents. Standing counsel. Ms. Mos, you will be appearing for secondary education. MS so puts in appearance on behalf of the respondents numbers 1 and 2. Who will be there for inspector of schools? You'll be there. 1, 2 and 3. Staff state selection board. 1.
Except if I think they can.
You'll appear for the selection board also.
1, 2, 3 and 4.
1, 2, 3 and 4.
Yes, sir.
Administrators, BDS Memorial High School.
Issue notice, my lord.
Issue notice to the respondents number 5 and 6. Requisites be filed within 3 days.
Much of. Item number 5.
And on the last occasion, your lordship directed that when there was no proposal for the transfer of the appellant, how could it be approved by the minister concerned? Ma'am?
Hello, I have gone through
The
it.
same controversy which we have already reserved the judgment yesterday.
Yeah, can I say one?
Yes.
I have heard that. Yesterday, I was sitting behind back, I was listening.
There
What
is
your-
no proposal of the
two-
education
two
department
queries.
anywhere,
2 queries, which was put forward by your lordship when I argued the matter.
because the record position is the same.
Yes, now situation, what your lordship has asked, I remember 2 things. One is how abruptly his name came, if I am not wrong, my lord. Your lordship want to see how abruptly, this is number 1. Number 2, the word pathetic, because 34 years you are in the particular home district. This is 2 queries which was put forward.
In addition, there to one more important query, Mr. Das,
yes.
which is probably the most important aspect of the case. In the entire exercise, fresh exercise, there is no opinion of the education department that these transfers are in the public interest.
Now let me answer, if you allow me, because.
Of course, you have a right to say.
Because government advocate, additional advocate general is appearing. That's why I said prerogative should be given, but with your lordship permission, I am taking.
Yes, yes, please.
My lord will kindly see one thing, which I remember, my lord, while my learned friend argued this matter, at page 95, note number 143, my lord will kindly see, my lord. This he says that his name doesn't appear in that list. If I'm not wrong, my lord, your lordship will kindly correct. This is what he said, page 95.
95.
95, note number 143, my lord. kindly see 95.
Yes.
If your lordship kindly see 95,
Yes, please.
note number 143, his name doesn't appear. This is what your lordship argued the matter.
We
Abruptly,
didn't
how?
argue. We didn't argue.
Yes, no, this
We
is,
argued.
his name doesn't appear.
Ah.
His name doesn't appear. Abruptly, how at 171, at page 170, or note number 171, 105, how his name came? This is what he does. So he cannot be picked up. Now your lordship will kindly see. His name at note number 143 will never come up. Why? Why, my lord? Now I will trouble your lordship with page 83, kindly see that. Why his name will not come up? Page 83. Lordship got 83, my lord. Page 83. His representation, kindly see the date. 13th of January 2021. Lordship got it, my lord. This is what he addressed to the minister. Now kindly see subject, prayer for appointment to the post of Deputy Director of School Education, so and so, so and so. Now kindly see first paragraph, your lordship will leave first, second paragraph. Moreover, since promotion to headmaster in 2004 till date, I have been serving in various capacity in different districts of the state for last 16 years. I have never been given entertain home district posting as of now, even after my repeated request. More so, my ailing mother is seriously ill and hospitalizing frequently, in which I could not attend her per se. So far, seniority concerned, my seniority position is so and so. I am one of the senior most officer in school education department. Thus, so and so 26 presently distinct are junior to me. Therefore, in the circumstances and considering my past experience, seniority and dedicated service, having good reputation, honesty, and integrity, more than 35 years to a department, my case may kindly be considered sympathetically on priority, thereby posting me at so and so as the tenure present incumbent shall be more than 3 years. For well, now this is now at page 84. Kindly see page 84, 4th of May 2021. His request was kept, and accordingly, kindly say serial number 1. You can cut is the appellant. DDE. Now he has been posted at DDSE alone. So, my lord, when 4/5/2021, his request was kept. So the fresh proposal came for transfer. Some request were made at page 95, which your lordship will kindly see 95 now. Now 95 will kindly see at note number 143. Statement showing transfer and posting of DDSE / principal for DDSE. So my submission, his name will never come up in the list because his prayer before the minister at page 83, he made a request for transfer. Accordingly, might on the next page, on 4/5/2021, he was transferred.
So that was executed.
So
That was executed. He was working
executed.
at alone.
So his list, what my learned friend argued, say he abruptly, his list will never come in the list. Because these are the statements showing, now I will show my law. This transfer, your lordship dealt up the matter yesterday. One of the candidate, one of the petitioner appellant who appeared and your lordship dealt up is at serial number 2. This is serial number 2.
Yeah.
So there are few of the candidates where requests are being made and different MLAs, some of the panchayat, they have my lord requested. Now your lordship will see at page 98. 98, after 11, my lord, the serial number 11, kind of superintendent may peruse and endorse the file to the competent authority for further necessary decision, that is 23/5/2022. Lordship got it, date. There's down below, superintendent may peruse after serial number 11. So these are superintendent may peruse and endorse to file complaint for further necessary 23/5. Now note number 144. May like to endorse the file to higher authority for government decision through DSC. Please. Now kindly see note number 145. Department has received so many application UA note from honorable for posting them as DDSC of the district against retired change of DDSC of the various district as proposed at note number 143. Now, my lord, so file may be endorsed to government for obtaining.
Mr.
for
Das,
the- Yes.
we are asking you a simple query.
Yes.
Does the education department have any role to play in the transfer posting? Is it supposed to have any role in the transfer posting? Or everything is to be dictated by the MLAs?
No, my lord, is not to be
So,
dictated.
That is what he says.
Department-
That is what he says. So many requests are being received. Let the government take a decision. Let us become redundant. That is what the entire file shows.
No, I'm sorry to say, my lord.
Show us one opinion of the education department
My
which says that these requests are genuine.
My
But
lord-
any particular.
My lord, for that purpose, your lordship will kindly see, your lordship have to see all the notes I have read, my lord.
Yes, yes.
I have read the
Read,
notes,
read,
my lord.
please. Which note says about the opinion of the education?
Now, my lord, it goes, my lord, minister is a head. Definitely the file will go
Let
to
us
the
see the
minister.
opinion of the minister.
My lord,
also.
my lord, kindly see 99. My lord, I am on, if it is abruptly this name came, the appellant name has come up, my lord, I have nothing to say, my lord. Your lordship will take a decision, I'll be out. Let me be very fair to your lordship. If his name has come abrupt, I have nothing to say, my lord. I have nothing to say in this case. My lord, what I found, that this is not an abrupt. My lord will kindly see now 99. His note number 147, kindly see, my lord. At page 99. Lordship got it, my lord.
Yes.
Now, this decision is will take a department. For serial number, this is department. For serial number 99, note number 147.
Yes.
For serial number 1 against the vacant post of so and so, Siang district after retirement, both the concerned HMLA, honorable MLAs have submitted joint UA note for transfer and posting of Srimati Oye Borong, Tatak, office at so and so. So this is what, my lord, the candidate, this is the person where she was posted Itanagar, where this appellant was brought to her place. Now, my kindly see, serial number 2, this is what your lordship dealt yesterday, my lord. So is one of the senior most principal department deserved for the post of against any vacant post. Serial number 8,
Yes.
Tommy Doke is one of the senior most so and so department deserved to be so and so. Serial number 10, Tage Kaki so and so, except see so and so who was promoted as principal and already served in 2 districts, East Siang and Pake Kesang, and so who was promoted in all others are newly promoted principal. Now this is, my lord will kindly may like to endorse the file to the honorable minister for decision, please. Now this file moves on at note number 148.
Yes.
This is regarding posting of DDSC Bolang Siang district vacancy arising due to retirement of Sri Talem Jama on 34, note number 143. My lord, that's note number 143, 95. Above gives the name of officer who have represented or for whom the UA note have been received for the posting at so and so. Now, note number 147 may be perused in this regards. Your lordship has gone at page 99, which I read, my lord. Following is the seniority of the 5 officers. Now, these officers, my lord, has been mentioned. Name and designation. Now, these are the. Now, if your lordship kindly see at page 100, 1, Tani Talam DDA 3. So, if your lordship kindly turn to page 101, kindly turn on top. Tani Tolam may be kept in the same post in the directorate. Right,
Yes.
my lord? Now, your lordship will again go to 100. That is number 2, Tomi Doc, DDSE 10. Now your lordship will kindly turn to 101 at serial number 5. Tomi Doke may be kept in the same post director. So now remains, my lord, number 3 is Marte Koyo Principal 20. Number 8 is Noam Rina Principal, where yesterday your lordship dealt, and Srimati Oye Borong Tatak DDSE, which has been transferred. That's not the case. Now your lordship will kindly may like to decide, please. Sends it to the file, note number 149. File may be routed through so and so to minister so and so. This go to 150, commissioner. Now 151, kindly see. In reference to note 148, which I read at page 99 down below, my lord. Posted number 1, transfer and posting. 1, Mrs. Oye Borang Tatak may be posted at DDSA Bolang Sang district. Number 2, Marte Koya principal, who is senior principal posted at so and so. Number 3, Naam Rina, senior principal may be posted so and so retired on month of so and so. Kindly turn to page 101, which I have read, 4-5. So now the position is this, my lord. These all number 4 and 5 may be kept. Now, Oli Boyang, my lord, which has been transferred, which they have transferred. Now, these files, file 101, file to endorse to Honorable Minister Education, perusal and approval. Kindly see note number 152. Approved, para 151, subpara 1. Cases of Mrs. Oi Barang Tatak. The rest case may be put up afterwards.
Yes, only one.
151. Am I
Yes.
right, my lord?
Hmm.
Now, my lord will send it to note number 153. Except rest case may be put up forward. Now, note number 153 is the commissioner. Note number 151, director goes. 155 is deputy director of secondary. Kindly turn to page 102, my lord. This goes to deputy director. Note number 156, administrative officer. Now, note number 157.
The one which was approved has been
Approved.
executed.
Of competent authority at note number 150.
That has been executed.
Yes, right. My lord, note number 158 may like to obtain signature. This goes on, my lord. 160, 103 goes on. Now, note number 163, my.
Yes.
Note at page 103. Please issue order. Thereafter, file may be put up for rest candidate. A state file is recalled by Honorable Minister Education to advisor to HM Education, please. Now, why for the purpose it was recalled? Kindly see note number now 164. Reference directed at note number 1. File is reput for government decision for rest of the candidates for who applied for transfer and posting at note number 143. Now, my lord, this is interesting. 165. This file was recalled by Honorable Minister Education and submitted to advisor to HME for obtaining decision of the rest proposal as order number 152. In the meantime, it is also informed that Srimati Oye Barang Tatak DDSE secondary education has been transferred as DDSE Bolang. Now, secondary education needs sincere and dedicated DDSE against her. My lord, therefore, these DSE may like to suggest the name among the DDSE posted at district. Deployment list of DDSE is placed at page 104C for ready reference. Hence, file may be endorsed to advisor for obtaining decision. Now, my lord, as this was exhausted, my lord, they want to call for deployment list at 104, which is not a part of the record. This is not where I have not found, my lord. Any record is not there 104. Why his name was chosen, my lord? This Dukan Katomel. So I am not aware whether it is list his name reflects or not. If his name doesn't reflect, well, I can't say. Then, my lord, of course, abruptly it cannot come in, which your lordship was concerned about. So it is malafide from where they have come up. So 104, if his name doesn't reflect, I have nothing to say, my lord.
That will ask.
I'll take my seat, my lord, if 104 is name. This is now 1 second, my lord, before your lordship looks into it. Now, this goes on, may like to obtain decision for higher authority, please. Now, 167, recall all this goes. Now, 170, directed transfer and posting of so and so. Now, at 171, after the list, if it is name appears, then, my lord, at 3, my lord, this was done. His name, my lord, Lucan Kathor, name appeared. If it is not in the list, my lord, of course, your lordship will take it. Record. Now, two things I just want again to give a reply of 34 years and decision in respect of what they have taken, my lord. Your lordship will see the record. Thereafter, I'll make my submission, my lord.
Yes.
If it is not in the list, I cannot argue, my lord. My father's argument.
Both of you are there, responsible
my
senior
lord,
counsels.
your lordship. First,
Both of you have a look. We are asking for assistance of Mr. Das and Mr. Mazumdar. Have a look at the list.
Well, I'll look at just one response from these notes. One very
After you have a look at the list.
well,
that will
Show
be
it, Mr. Chaudhary.
that will end the matter, my lord.
Yes. Show it to both learned seniors.
Yes, ma'am.
Before showing it to us,
Yes, sir.
show it to them.
That's us.
Mr. Mazumdar, you also join in the inspection.
well,
That's 16. Yeah, ma'am. Huh? It's 16. Take on the other. আপনাকে দেখাই দিচ্ছি।
So let me. Serial number? Okay. This is 8140C,
104C,
9110.
exit order লেখা আছে।
This should happen somewhere between 165 to 171.
Yes, madam.
104, I have, my lord, this. I
Note
have not-
number, Mr.
No,
Das.
my lord, I have
Mr. Das,
Yes.
somewhere between 163 and 171.
Yes.
This discussion must have been made. Let us see that.
এক কপি দুটা দি দে মোক। নাই নাই অফিস করে।
170 is very clear, madam.
Yes.
This is the list. দুটা কপি আছে। এটা ওলাই দিছে।
Straight to the task.
না?
You found something?
Original. Your lordship,
My lord,
I have given the page number, my lord, page number 16, my lord.
Yes.
Your
This is a
lordship, that is,
deployment list. This is a deployment list.
yes, madam, this deployment list is that concept that has been, my lord. 165, that was mentioned, my lord. Your lordship,
I'll point out.
my lord, may I submit, my lord? Fast, your lordship, kindly allow me to
Hold on,
submit.
have patience. Yes.
Yes, my lord. Note 165, my lord. The file was recalled by Home Minister Education and submitted to advisor HA for obtaining the decision of the proposal of note 152. As already said, my lord, Ole Borang case has been mentioned in there. Thereafter, in the meantime, it is also informed that Ole Borang DDSA has been transferred Boleng. Now secondary education needs sincere and dedicated DDSA against her, therefore may be like to suggest to the among the proposal district, the deployment list of DDS is placed 104C for ready reference. Hence, the file may be endorsed advisor to HME obtaining decision of the government please. Then my administrative officer has sent, then it is go to the deputy director, my lord, 166. Then it is go to the my lord, director, my lord. Then it is a
Mr.
e-file.
Chaudhary, where is the discussion that Duquesne Khatuma should maybe transferred from this place to this place? One fine evening, you just straight off issue the list.
My lord, it is,
Where is the application of mind
that is my lord, my humble submission.
that this
before-
man has been sent on his own request?
Yes,
His
ma'am.
mother is ill.
Yes,
What
ma'am.
is the such pressing public interest that he has to be shifted out of the blue?
Only my lord, that been mentioned in
Other
my
than
lord,
the deployment list, where is the discussion about his name?
deployment list name has been mentioned, my lord. He is the
Of
senior.
deployment
most of-
list, there are n number of persons.
Yes,
So you
ma'am.
could have picked out anyone without any application of mind or without any discussion.
That was given by the ministers as remark, my lord, on the basis of that deployment. It is a e-file, my lord. I want to satisfy your lordship one thing, my lord. Your lordship kindly come to the 170, my lord. It is not that only his case has been considered. As direct transfer posting of the case, Martek and present principal GSA, DDSA, Likabari Lower Siang and Tagakati DDSA, director second is put up again for approval fees. Then your lordship comes to the 170. The transparent posting of following DPS's principal approved mentioned below. He only, my humble submission, my lord, before your lordship. A minister as a my lord, head of the my lord,
We
department.
put you a simple question, Mr. Chaudhary.
Yes, my lord.
We hope that you can understand the query.
Yes, my lord.
Approval can be of a proposal.
Yes, my lord.
Where is the proposal?
That is not available.
Not there.
That is not available. I could not find the proposal.
Yes, Mr. Das, that is your
My
answer.
lord,
No, that's all, that's enough. He said then what your lordship. Two things I just-
I want to sing one thing, my lord. You also kindly one thing, my lord. Page, my lord, 19, my lord. কোনটো আছিলে তেওঁৰ?
Page 19.
20,
Yes.
28, my lord. Lordship has correctly said that all person has been named, my lord, to the, my lord, MLA or minister. How he has come to the department, my lord?
Who?
This person, token cutter, page 28.
Yes, that is not our domain. You are not cancelled the transfer order. He
My-
made a request, all right.
Yes, my lord.
Nobody objected against that.
This was made by the PWD minister, my lord, as well other minister. On the basis of request, he was transferred to that place, my lord.
Yes, that is fine.
Right.
Yes,
So
he was
his
transferred to
request
that case. my lord.
was objectively considered and it was found to be genuine.
Yes, my lord.
So there was an application of mind. Here you are saying approved,
Yes, my lord.
approved,
Your lordship want to know the departmental proposal. That is not available. my lord.
not there. That is what we are saying.
Yes,
That is what we are saying, Mr. Already, yes.
Two things are just.
Yes. On the
Only
one
thing
side,
is that, my
you
lord,
say,
only
"Yeah,
thing
I
is
will,
that, my lord,
Mr. Das,
He
on the
wants
one,
to
you
argue.
said 3 times.
I'll-
If there is
I'll-
no
one thing-
proposal, I am out of the court.
My lord,
Yes, my lord.
let him.
My lord, only thing is the deployment list has been sent to him.
Yes.
This was
Then he
coming
just
to
ticks
the-
one name.
to the, my lord, department, my lord, and ultimately it goes to the minister, my lord. Minister on the deployment list, take the decision. That
Take
is
the
my
decision.
comment.
That's it. There is no input from the department. No, this man is doing a good work. Why you are disturbing him? He has not completed 3 years.
Just
No.
1 year.
Yes, my lord.
No, let it be 1 year, 2 years. How his name came up, your lordship has seen this. 104, see the deployment list, his name came. Right, my lord, when the matter, my lord, he was transferred from Alo to Itanagar, he represented the matter to the government.
Itanagar to Alu.
From Alo to, he was holding the post in Alo. Then this Srimati Olive was transferred.
Hmm.
So they called the list, deployment list. Then Dukan Kato was brought. My learned friend's client was brought from Alo to Itanagar. And my lord, my client
Was sent to
was
Alu.
was brought to his place.
Vice versa.
But
Yes.
this is what has happened. Now, when he was brought, he was aggrieved, and he, my lord, represented the matter to the government. My lord, this is what your lordship has said, that how they can take, whether it is application of mine. My lord, then my lord, he represented the matter at page 88. He represented the matter to the government.
Let's-
Kindly see at page 88.
Yes.
At page 88. My lord will kindly see representation for cancellation of transfer order.
Yes.
Right, my lord, at page 88.
Mhm.
If your lordship kindly see third paragraph. During all this period for more than 18 years, I was not given any opportunity hometown posting. I have been serving only for 1 year at so and so. But before completion of tenure, I have been transferred back to Directorate of Secondary Education, which is in violation of principle of natural justice. There is no adverse record against me in all these 38 years of service. Department of Education never been met out such humiliation and mental torture. Moreover, I have only 2 years left to be retired on superannuation on ground of looking after my ailing mother, whose age is more than 90 years. She is frequent need of medical care for which my personal presence is required. Besides so and so, he's talking about me, my lord. So and so, who has been posted against me, as was newly promoted, who has not yet completed even 1 year as principal. He is junior to me by many years. As such, there is enough time for him to be DDSE in times to come. So in the I sincerely appeal. So he made an appeal to the government. Now, my lord, this appeal was not acceded to it. He filed the writ petition before this honorable court. First writ petition. When he moved the writ petition, this petition was pending. Court said that no, what we'll do, let a status quo order to be maintained. In the meantime, let the government decide his representation.
All right.
Then he can come back. So now, how the representation was dealt off by the government, my lord. Kindly see, there is a speaking order which was put to challenge by the client at page 121. 121. 121. This is, my lord, will kindly note down 24th of August 2022. He moves the writ petition, your lordship will kindly note down the first on 4/8/2022.
Yes.
He filed the writ petition on 1/8/2022. Now, the court directs the government to dispose of, and this is the speaking order. If your lordship kindly say last paragraph. Whereas, after getting the certified copy of the order, undersigned call for record pertaining to matter to pass the speaking order. Record shows that the
Mr. Das, before you go to that para, the reason for rejection of the representation is very apparent.
Yes.
In the very second para below the 2 grounds which he has set out.
Yes.
Whereas, without waiting for reasonable time for considering his representation, tell us please just the third para from top.
Third paragraph, yes. Whereas,
Without waiting for now,
reasonable
Mr.
time-
Das,
Yes.
from your experience, let us know at what pace do the representations move in the government? Tell us fairly.
Yes.
How many writs you have filed saying that my representation is pending, please give a time.
It takes.
Hundreds.
Yes,
So-
of course.
So what is this ground?
Yes.
Without waiting, how long would you take? Is there a time frame that we'll decide the representation without executing the order? So the man going to the court has hurt them.
No, that's right. That's
That is
right.
the problem.
No,
Yes.
no, you're also right. Absolutely correct. Now,
Yes.
if your lordship kindly third paragraph, whereas after getting the certified copy order, undersigned call for the record pertaining to matter to pass the speaking order. Record shows that Dupen Kato DDSC has been transferred Directorate of Secondary Education or Administrative Agency in the public interest. Service of an experienced senior DDSC is required in the Directorate of Secondary Education, for which he has been transferred. Any public servant can always be transferred in the interest of public service or in the administrative agency. It is submitted Directorate that there is no statutory rule in force in the state of Arunachal Pradesh prescribe any particular tenure of posting at DDSC, any place of providing hometown posting. Hence, the claim is unsustainable proposition, accordingly untenable. Further, his transfer from DD Allo at DDSC at so and so does not adversely affect his service condition, position, status, etc. Whereas, as per record, date of birth of so and so 2 years away left for attending super, therefore, he can be transferred anywhere at this stage. Further, the personal and domestic ground can be accommodated to the extent possible in public interest. Whereas in so and so, a joint. So this is, my lord, the representation speaking order which has been disposed of.
Let us see the transfer order once.
Yes, your lordship will see the transfer order.
And before that, Mr. Das,
Yes,
come to page 105.
105.
Where is the word public interest used in this?
I'm
Should
sorry.
have been in the discussion that in the public interest, this is necessary.
That's a lordship, my lord, that's a note at page 160, note 103, my lord.
All right, let's see the
Yes.
June transfer order.
Yes,
And
my
page
lord.
number.
my lord, if your lordship kindly see this. Yes, my lord, if your lordship, I'm troubled with lordship 103.
Come to please page 87.
Yes.
Where-
Then I will take 103 public interest. I
Yes.
will just so. My lord will show in page 87.
Yes,
Yes,
this is the transfer order.
Yes.
Wherein
87.
it is mentioned as public interest.
Yes, correct.
Where in the discussion they say
Yes,
that
my
in the
lord.
public interest,
Yes, yes.
this is necessary. The public interest is probably the
Yes.
desire of the MLAs. That is the public interest.
Go to the public interest.
Yes, read the word
Yes.
public interest in this
Yes.
discussion.
165.
Yes, please.
My lord, the 165. 165.
Yes, please.
The file was recalled by Honorable Minister and submitted to advisor for obtaining decision for the rest of proposal order number 152. In the meantime, it is also informed that so and so has been transferred. Now secondary education needs sincere and dedicated DDSC against her. This is what public is, sincere and dedicated. What more?
The
My
others-
this is public
others are
interest.
not
It
sincere
has
and
not been
dedicated.
spelled out.
Yeah, others are not sincere and
Maybe,
dedicated.
my lord, My
If the officers are not sincere and
my lord,
dedicated,
I can't.
why post them as
Your
principals
lordship
even?
My lordship can, I can't. I
Just
no,
an eye wash.
But I find, my lord, honestly, I find that this is. My lord, just one thing,
Yes.
just what I felt, I read it.
Hmm.
This is an assessment which is made by the government. When he filed the representation, he had some grievance. So that was, my lord, grievance was met out, has given a speaking order that this is what assessment has been made by the government. Now, with great respect to your lordship, now the assessment which has been made by the government, now your lordship has to reassess the assessment, whether the assessment is good or bad. With great respect, I am saying, one is malafide, next second is about the assessment which was made. Now, your lordship allows me, my lord, the judgment which was passed by the learned single judge, your lordship, how he dealt with the assessment part, the public interest, that kindly see it. Page 45 kindly be seen, my lord.
Yes.
Page 45, para 16, my lord. My lord, I will not trouble enter 16. First, second, third, fourth, fifth, eighth line from the top 16. Once the employer, lordship got it? Once the employer.
Yes.
Once the employer has made some assessment on suitability of an employee for posting at a particular place, it is not for this court to substitute the assessment.
Yes.
It is not for the court to substitute the assessment made, as the court does not have the expertise to assess the suitability of an employee to be posted at a particular place, nor it is within the domain of this court or is a function of this court to enter into the arena of assessment of suitability of an employee for posting at a particular place. Now, this is 165 where note has been made. The representation was disposed of, the grievance was taken care of by the government by a speaking order, and this is what the finding of the learned single judge. Where is a question of reassessment in the public interest? Some assessment has been made. Whether with great respect, whether you all say reassess because of the suitability part. Now this, my lord, I found one judgment, your lordship, that's recollect the judgment of Wander versus Entox. At paragraph 14, my lord, 1990. Kindly see, the order passed by, it is a matter of an injunction, whether it can be reassessed by the court, passed by a learned single judge. A matter of injunction by principle, I am showing, kindly see at paragraph 14.
Yes.
I'll show thereafter, my lord, paragraph 14, my lord.
What is the position? Who is working where now?
I have been working in my particular
And
long time
he is
because
working at Itanagar.
he is in Itanagar.
Itanagar is already working
Yes.
since August.
Yes.
So Mazumdar, 1 year has passed almost.
1 year.
10 months.
If the
Now to
order-
change
if your
the
lordship-
scenario.
My lord, if your lordships are here to do justice, my lord. If the lordships find, my lord, the
Mr. Mazumdar,
expressly the
let us
entire,
let us come to that discussion
my lord,
wherein they see
my-
the list, and then there is a requirement that an experienced person is required to man
my
the
lord,
post of director at Itanagar, and
My-
that is right,
my-
because it is the head of the entire state. The state administration is to be seen. They find that the person is inexperienced hand, and his presence would be good for the institution establishment. That satisfaction, whether the court can interfere.
my lord, this entire satisfaction which your lordships are now saying is the satisfaction of the minister.
Yeah, so
Department,
he's
my
the
lord,
education
I'll
minister.
just know one thing, my lord.
You
Lordship,
see, no. It's not purely the satisfaction of this minister. What happens is that lady is shifted out of Itanagar,
my lord,
the respondent. And once that transfer is made,
my lord.
then they need a person to replace. For that purpose, a query is made, who to bring. The entire list is presented. The list is seen.
My lord,
And
here I'll just, if your lordship permit, I'll interrupt your lordship.
Yes.
Lordship, may kindly see, it is Mr. Kakki who was sought to fill up that post, becoming vacant. Lordship, may kindly see page 103. This they are not pointing out.
Where is that?
Page 103, note 165, Lordship, may kindly see. Once again,
103.
103, page 103, note
Yes.
165.
Hmm.
It says the file was recalled by the Honorable Minister Education and submitted through advisor to HME for obtaining decision to the rest of the proposal as order note 152.
Hmm.
In the meantime, it is also informed that owing Barang
Oi Barang
DDC second education has been transferred as DDC Boling. She was in Itanagar. She has been transferred to Boling.
Hmm.
Now, Lordship, may kindly go to 152. 152 is at page 101.
Yes.
It says approved para 151 sub para 1.
So, Oi Barang Tatak as DDSC Boling.
Yes, this is Boling.
So that was approved.
No, Lordship, may kindly see page 104 now.
Hmm.
104.
Yes.
I'm sorry, 105. Starting from 104 bottom, note number 170. As directed, the transfer and posting case of so and so, present principal of GHSS, Telam, etc., DDC, Likabali, we are not concerned with that. And Sri Tage Kakki as DDSC at Directorate of Secondary Education in Itanagar in place of that lady. This is after this 165, my lord. After that, there is no question of picking up another person by the minister. This is the position, my lord.
That is the
And the
recommendation.
names of these two ladies, this lady and Kaki and these gentlemen are all there in the list of 11 persons. I am not there in the list of 11 persons.
Yes. So how was this proposal? The approval is of the proposal. Proposal is for Tage Kaki.
Yes.
Why is not accepted? Why is that not accepted?
101, my lord.
101,
101.
105.
101, kindly see.
Yes.
Tage
Kaki was referred earlier.
Yes.
His name is there in the
Yes.
list of 11 persons.
My lord will. My lord, I will show it, my lord. Kaki.
Our name is not even in the 150.
Once again.
And I have shown, my lord, there are 2-3 reasons for which I have been picked up. I have picked up a special direct quarrel with the minister. I did not
My lord,
satisfy him.
I'm sorry, I'll just give a reply. Kindly see at page 99. 99 serial number 10.
Yes.
Serial number 10, 99. Serial number 10, Tage Kaki DDSC so and so has given a UN note requesting for his continuing at DDSC for another 2 years. So he remained there. So where is the question of picking up, my lord? He remains there. Kindly see at 99. So that is why decision is 101.
But that was not accepted, sir.
Yes.
That was not accepted.
Yes.
The department recommended Tage Kaki to be sent as DDSE at
My lord,
the Director of Secondary Education.
my lord, page 105 up to the first part, it is the department. Thereafter, it is the minister. Table,
Minister.
even the table has been made by the minister. My lord, my instruction is.
All in Arunachal Pradesh, Lordship, he knows he has dealt
I
so
know.
many matters.
Yeah.
Now only has to Lordship look into it.
He proposed that we make it serial number 10. Not accepted. And rather it was proposed.
We said as a- yes.
Suddenly he will not get 105 approval to such. 105.
My lord,
Yes.
my lord, now kindly see at page 105. Who has done it?
Yes.
105.
And now we have to put an
No,
end to it. sir.
105.
Enough
Yeah,
discussion.
we are 105. This is approval by whom? Advisor.
Approval of what?
Advisor.
Advisor says Tage Kaki as DDSE Directorate.
No,
That is what the advisor says. Yes.
That's
Read,
the
sir,
only-
page 105 top.
Yes.
Who has signed it?
My lord, this is only an advisor. He puts up the file and the minister. decides.
Advisor to the minister.
I know, my lord. The
Yes.
minister, advisor can put up a file. The minister has taken a decision, my lord. And my
Mr.
lord,
Das, please read the entire note again from
Yes.
104.
yes. As directed.
As directed. Who
As
directed? it?
directed.
Mr. Das, just hold on.
Yes.
Who directed the advisor? It can be presumed that the minister directed.
Yes, maybe, my lord.
So minister directed, that note was put up, then suddenly the tenor of the note was changed.
My lord,
For what reason?
my lord, the reasons.
Why does, then the minister is the party?
My lord, then, my lord.
There's an allegation of
my lord,
malafide.
The minister, my lord, then, my lord.
Yes.
My lord, then why? My
Is
lord,
there,
that.
is there anyone from Itanagar? Yes. Connect them, connect him. Yes. Who do you
My
represent?
lord, I am
gentlemen?
appearing for respondent number 6 for the
Yes,
minister.
all right, tell us there is
My
an
lord,
allegation of malafide.
My lord, firstly, kindly come to page number 44 of the impeached judgment and order passed by the not a single judge. Lord.
Yes, please.
In para 14, Lordship, what the
Yes.
appellate appearing in the writ petition, what he says is that
We have had
he,
enough, Mr. Counsel, we have had enough
Lord.
discussion on this para. Unfortunately, you are not a part of the discussion because you did not join. We believe that these observations are cannot be referred to the counsel for the petitioner. They never
Lord.
give it up. This is the finding of the learned judge himself, which is under
Lord.
challenge. Yes. Come to page 105. How do you explain? 104.
Lordship, I'm coming to it, Lordship.
Yes, 104, please. You have it? Yes.
Lordship.
Hmm.
Yes, Lordship. This is the noting, Lordship.
Yes, come to note number 170. Your advisor acts under whose directions? Your advisor to the minister acts under whose directions?
My lord.
The advisor to the minister, he is supposed to act under whose directions?
He, of course, my lord, he has to act under the direction of the minister, Lordship.
All right, then read, all right, that's clear. Then read note 170, please.
Note number 170, Lordship.
170. Yes, please.
Yes. As directed, Lordship, as directed, the transfer and posting case of Sri Marte
OU, present
Marte
principle of
Koyu,
yes.
present principal of GSS Telam, HDDC Likabil, Lower Siang District, Tage HDDC is Director of Secondary Education is put up again for approval plea.
All right, so this, the advisor put up the note on the direction of the minister to approve it. The minister, all of a sudden, in note 171, issues the list, wherein the earlier recommendation which was made on his request, on his direction, that is changed. What is the reason?
Lordship, I'm sorry, since there was a network problem, I could not join earlier, Lordship. But Lordship, here, Lordship, or advisor to the minister.
Mr. Advocate, Mr. Counsel,
Acted on the direction, Lordship.
Mr. Counsel,
Yes.
if you need, we will give you a day's time to complete your instructions. But there are clear allegations of malafides. There are written notes. And if we deal with those notes, things may become uncomfortable. That is what we can say. That is just an observation, subject to affirmation, of course. Because there are serious allegations, there are letters, there are recommendations from your side to grant contracts against the policy. The man doesn't act on it and he is transferred. Whereas there is no proposal for his transfer. The proposal is of another man who is favored. So that is for you to decide. Take an objective decision. We'll give you a day's time if you want.
Lordship might have seen my senior counsel for the respondent, private respondent must have apprised Lordship.
All right. So you are happy with whatever has been argued. All right. We'll deal with the submissions then. Very well.
Lordship,
Yes, please.
the transfer of this appellant, Lordship, as Lordship has seen, we need very good and sincere officer
Yes.
as the directorate, Lordship.
All
So,
right.
therefore,
So the others,
we're looking for a good and sincere officer,
that we will-
Lordship. And
that we will decide, gentlemen, whether it is for that reason or the reason is something else. That we will decide. You want it to be brought out on the record under this judgment, we will say so. If you are pressing us, we'll say so.
Well, one very vital information. In the directorate in Itanagar, there are 3 sanctioned posts of DDSE. Now, including me, there will be 5. 5 persons have been.
Is that so? Only 3 sanctioned posts?
Yes, man.
Can you say so on affidavit?
Yes, man. My instruction by my land junior.
Now this takes another turn, gentlemen. Say so on affidavit right now.
Yes.
All right. Well, we'll record it then. We'll record it. Then, Mr. Das.
Lordship,
My
may
lord,
record.
honestly, transfer case, I have not read so much like this, my lord. My lord, is it like an ultra vires of an act?
Director of Education is not the party in this case, my lord. And everything has been addressed in the director.
That he is second.
My lord, Director of Education, everything is available in the Director of Education. And he did not make Director of Education is the party. Every record, RTML, everything is.
So
available to Director.
you want to go on those technical issues? Then we'll pass the order just now. We'll render the judgment just now.
No.
with findings dealing with the governments of Melaphites? Are you sure that you want to invite that?
No.
Let him file.
If that statement comes out to be correct, Mr. Chaudhary, then we are telling you that there will be serious consequences.
Let him file.
Now,
Let him
we are
file.
recording it, Mr. Das, right now. You come back and tell us at 2 that what this statement is.
Let
correct.
him take the instruction over phone, my lord.
Yes. Right now, telephonic information that there are 3 posts, and with his posting, there will be 5 TDSs at Itanagar.
Can give me 2 days.
2 o'clock.
I have to take written instruction.
Telephonic, first take telephonic instruction, then we will record it in the order and then post it after 2 days.
There are 3 processes second.
There are only 3 posts, and with this posting, there will be 5 officers on the against 3 posts. Understand? All right. Come back at 2. We'll reconvene the court at 2 for this matter. The record वापस दे देंगे.
Deeply obliged.
Deeply obliged.
Much obliged.
This will, Mr. Das, this will create a very interesting.
Transfer, my lord, I have argued for transfer
My lord.
so much of.
My lord, there are in fact,
We have done
During-
lot of cases, my lord, together.
during deliberation, my lord, discussion.
Probably you will not have seen Mr. Mazumdar arguing so passionately in any other matter.
My lord, there are
But,
others, since these are not pleaded, I am not arguing. Even in respect of Malafide, there are other issues, my lord.
Forget about that.
My looking homework. So somebody is saying transfer matter, you are looking into. So, deeply
Obliged.
obliged.
We have also given you so much time.
Yes, yes. So
You
I have
kept
seen,
us engaged
I have
for quite a long time.
my lord, I had seen yesterday,
Yeah.
that day also.
We started court proceedings at 11 o'clock. We are only at cylinder number 5. Yes.
Deeply obliged, sir.
Item number 6.
May it please.
Yes. Mr.
In this case, my lord, there was no allegation of bias or malafide, my lord, against the my lord, selection committee. And here, my lord, the
Promotion has been denied without any reason.
my lord, there
What is the reason?
my lord, no reason.
There were 11 posts.
My lord,
You selected only 5.
Yes.
Why?
My lord, we reserve the right under the notification. We reserve the right to, if we that.
It is an
no suitability-
interview-based selection.
Lordship,
It is an interview-based
it
selection.
is not an interview. It is based upon the last 4 years service record also. Lordship,
Yes.
kindly come to my lord, the notice, my lord, the notification. That is 12/10/2022, my lord, on which
Come to page 3. He has already retired. Why
he
you
has
are
retired.
fighting against him.
He has retired, but the problem is, my lord, if this is upheld, my lord, every year the selection committee will be, because what is happening, my lord, from scale 3 to scale 4, we always get less candidates, my lord. No, nobody wants to go.
You give a statement that we'll treat his case to be an exceptional case because he has retired, and without this judgment,
Lord, the learned
being of
Singh-
presidential value,
If
the
I
appeal
may
will be
say so,
disposed of.
if I may say so, my lord, the learned single.
Then what we'll do is we'll admit the appeal and reject the prayer for interim relief.
Lordship, as far as that. is
Admit prayer for interim relief rejected because the respondent has superannuated.
Lordship will allow me to take instruction, my lord, on the question of the precedent issue. Lordship will take it up on Monday,
1st August.
First.
For today,
let it be on 1st August.
1st August. Yes.
Obliged.
Item number 7.
Yes.
Lordship, this pro bono application, Lordship. This is, Lordship, assailing the petitioners. The amendment of the
Mr. Counsel, you are petitioner in person.
Lordship.
Then you can't wear a gown, you can't
Yes.
wear a band,
I'm
please.
very sorry, Lordship.
Go out and do it. Don't disrobe yourself in the court. Pass over.
Item 8.
Yes. Water logging,
Yes, my lord.
issue notice. Serious issue. For issue notice, MS Bodloi puts in appearance on behalf of
I'm for responding 1 and 2, your lord.
1 and 2. Forest Wildlife. Respondent number 3, Ms. So and so. Respondent number 4, Deputy Commissioner. 4 and 5. So and so. number 6,
Six to.
they are private parties.
Yes, private party.
Steps for service upon the remaining respondents be taken within 3 days whereafter process be issued. It is happening all over the world. We are not realizing and now see this. I was just hearing that in Florida, the temperature of the ocean. Yes. The highest temperature is 31.
Ships, I have a prayer. The SC revenue may be reflected in the cost list.
The name of SC revenue shall henceforth be reflected in the cause list. Sufficient copies of the writ petition be provided to the standing council who have put in appearance on behalf of the respective respondents. The rule is made returnable in 4 weeks.
I'm attached.
And madam, you need to take instructions because this is a serious issue which affects every citizen.
Yes, my lord.
This is not
Really.
an adversarial litigation as a matter of fact. Ms. Saikia, would you like to come into this case? It deals with blockage of all water bodies and waterways, which is causing the waterlogging problem. You would be required.
Yes, Lordship.
You'll, Ms. Saikia puts in appearance on behalf of the state authorities. Notice to private respondents. They have pointed out a few private respondents, but they would not be the only persons.
Lordship.
This problem will be there for at many places wherein the natural water flow is blocked. That is bound to create waterloggings.
Lordship.
So you have to take stock of the entire
Lordship will take it seriously.
Yes, take it seriously.
Item number 10.
Because that is a stark sign of bad administration, which the regime would not like. That this allegation should come in.
This matter also may be taken up on 24th, Lordship, along with that.
24th.
On 24th.
Maybe placed before the environment bench
Yes.
on 24th. The rule is made returnable on 24th. Thus the service is permitted.
In the meantime, we'll try to file the affidavit. Highly obliged.
Item 10.
May it please your lordship.
Whole pension.
Similar matters.
Admit issue notice.
Already
so and
admitted
so.
by your lordship.
Yes, yes.
Maybe.
Can you give out the number of the other matters?
Yes, my lord. The other matters is read appeal number 220, 229 and 230, my lord.
All right. 23.
Item 11.
Obliged.
Provincialization. List before the special bench constituted to hear matters relating to provincialization of services.
Lordship, item 12 as well.
Same order. Issue notice and then list.
Much obliged.
Item number 15.
Can do anything.
Wait, please, your lordships. My lords, in this matter, I appear for the response number 6. I need some more time to file my affidavit.
It's very easy. That's eligible. The device chance. Yes, about discussion. Yes, all right. You are for the respondent number 6.
Yes,
Affidavits on behalf of the respondents. Yeah. The respondent number 6 has filed an affidavit already.
No.
Page number,
No.
page 91. What is that then? Yes. Dasti service. Oh, affidavits on behalf of the respondents have still not been received. Further opportunity of 4 weeks is granted for doing the needful.
Item number 16.
Compliance
Yes, Lordship.
done?
Yes, Lordship.
Yes, gentlemen.
My lord.
After long struggle, it's done.
My lord.
It is stated that possession of the land in question has been handed over to the petitioner, thus, directions given by this court earlier have been complied with. Accordingly, the writ petition is closed.
My lord, just a direction, if any papers are there with the bank,
Uh,
any papers.
in case, any title documents or title or allied documents of the land
Yes, ma'am.
are still available with the bank, then the same shall be.
Your lordship, I have already handed over in the year.
If,
My lord.
then the same shall be handed over to the petitioner.
My lord.
He has suffered for long.
Yes, sir.
So only with the pressure we created through Madam Boda,
Your lordship.
that it could happen.
My lord.
This file is going on since 2019. Should not have taken more than 7 days.
Item number 17.
Yes. Wrong evaluation of answer sheets. Yes.
Lordship, pleadings has already been completed.
So you want us to list the matter for hearing?
For hearing, lordship.
All right, the pleadings have been completed. The writ appeal is admitted. List for hearing
After
All
2
right.
weeks, lordship.
up to 2 weeks.
Item number 22 and 23.
Lordship is pleasant, this matter may be taken up for final disposal.
This is in the hearing list already. It is listed for hearing, Mr. Saikia.
Yes, Lordship. The issue in a nutshell is that, Lordship, the Higher Education Department rejected the proposal given by the college authorities regarding a recommendation given for selection of the principal. So we have basically rejected it on the ground that the concerned person in favor of which the proposal came, Lordship, he did not fulfill the basic criteria of eligibility.
All right.
He did his master's degree where under the UGC regulations, 55% is the norm. He got 55% by getting 6 additional grace marks.
Okay.
Whether that is permissible or not. That is one aspect. The other aspect is, Lordship, he has to be a supervisor, he has to be a guide under the regulations of UGC, which he did not fulfill because he showed that he was a guide of some undergraduate courses, which is not permissible. For UGC's guideship, it has to be either MPhil or PhD.
PhD.
So these are the 2 basic grounds, and we have to also look into whether he is having a good academic career or not.
Good academic record.
So his academic career says that he got in matriculation, he got 48%. In higher secondary, he got 65%. In BA, he got 44.34%. In MA, he got 55% by getting 6 additional grace marks.
Whether good academic record is a criterion in the guidelines?
In the guide, yes, Lordship.
Read para 4, sir.
If Lordship is pleased to take the.
There is
item
a
number
reason of
23.
rejection. First, Mr. Saikia, can we see the reason of rejection?
Yes, Lordship.
Page.
In our affidavit, we have very clearly said, Lord.
There must be an order. No?
Page 51.
Page 51, order dated 5/8/2016.
Yes.
To the president from the director, in inviting reference to the subject cited above, I would like to state that the proposal submitted by you via your letter mentioned under reference in connection with the approval of appointment of principal.
Page 51. No.
Page 51. Lordship is taking
Yes.
the.
50. Yes.
State or appeal to it.
State
51 is the vernacular. Yes.
It is found it's not in order in incomplete form. Further, you have failed to furnish the required particulars even after instructions issued by this directorate by letter dated
18/7/2016.
Will you please, this is page 50 is
Lordship is taking,
item number first only, this,
Uh,
your 195.
no,
Writ appeal
writ appeal
194.
284 I'm submitting.
State or appeal to 280.
The state has preferred the appeal.
Okay. But ये कोई गलत है। 284 is the state of Assam. दोनों में file को एक ही दिया ना। Why is the private person, the aspirant file an appeal?
My lord, I represent the governing body, madam.
Oh, all right.
Governing body
And
of
who
the
is for the aspirant?
I-
You're there. For the respondent. Page 51.
So this page 51 have lots of got it.
Yeah, yes.
It is found not in order and in incomplete form. Further, you have failed to furnish required particulars even after instructions issued by this directorate by letter dated 18/7/2016. Therefore, the proposal submitted by you has been rejected and cancelled with a direction to reinitiate the whole process of selection by observing all formalities as per guidelines in force. The matter may be treated as urgent. So against this, they have come. And if lordship is come to the previous page, page 50,
Yes.
what we have requested in inviting reference to the subject cited above, I would like to request you to furnish the following documents, particulars in connection with the according approval of appointment for principal of your college. Mark sheet, certificates of the selected candidate. They withheld this document from us.
Okay.
Later mentioning the post against which the appointment is to be made, original individual marking statements, etc. But the main concern is lordship. Then number 6, research guidance certificate. So we have in our affidavit, they have challenged this order of 5/8/2016. So in our affidavit, we have disclosed in which areas they have defaulted. And when we asked for these documents, they were not providing us the documents. So this rejection ground is on 2 counts. One is that they are not fulfilling the requirements as per the guideline, and
No,
also
the letter
the
doesn't
proposal was
say-
incomplete.
Doesn't say that they do not fulfill the guidelines. No.
They are withholding those information from
So
us.
that is the only reason. That is the only reason.
But when they came before this honorable court, we said that their own case, they have annexed all these documents, which we are asking. It was not providing to the authorities who has to give the.
That is what we are saying, Mr. Saikia. Your rejection is not for the ground that he does not satisfy the guidelines.
We have pinpointed that,
But
and
you
they are
can't
not giving us
supplement-
it.
You can't supplement the reasons in the order by the reasons in the affidavit. That is a settled law.
That is, no, that settled law has been now overruled in the Silpi Constructions case.
Let
In
us see.
affidavit, we
Let
can
us-
always supplement.
Let us see. Which
That is in respect of tender.
That is a different thing.
The tender is a different ballgame, but when the matter is adjudicated before the honorable court.
Yes.
Now, one thing is very clear. If we read page 50 with page 51.
You had asked for the document, they did not supply it.
Yes, now the documents are before this honorable court.
Learned single judge says, you take a fresh decision on the basis of the documents.
No, the learned single judge went ahead. The
Yes,
learned single
because
judge.
you invited that observation by taking a stand in the affidavit. That is the reason you asked us to adjudicate. That is why we adjudicated.
The adjudicator is perfect. Who came to the court? They came to the court and they
Yes.
came with the complete documents here.
Yes.
So when these documents were there, we have to respond. We responded. And on top of that, what will be the end result? If the reinitiation is taken place,
Yes.
the thing will be done same way.
We can't prejudge. We can't prejudge.
The honorable single judge says, because those observations have to go. The honorable single judge says, guideship is not required anymore. That is number one. And number two, getting grace mark also qualifies him to be an eligible candidate. These two observations, if lordship is pleased to set aside, then there is no difficulty. Ultimately, the authorities will have to go for a reinitiation of the selection process. That has to be done because nobody is selected as on
Let
date.
us see that discussion by the single judge. Let us.
That discussion, lordship. Yes. It starts from paragraph 23.
Not there.
It starts from paragraph 19,
Yes.
page 193.
Sir, 18 Yeah.
Para 18, it is a quoting.
Quotation of the.
Quotation of
UGC
the rules.
guidelines. Yes.
Yes, if I am allowed to read that, Lordship, because that is very crucial. Ultimately, it will boil up into that provisions of the UGC regulations.
Yes.
I am also appearing for the UGC also. In this case, the UGC guideline, Lordship will find at page 62. I'm not reading from the quotation.
Okay.
Page 62. What are the norms? Recruitment and qualification. The direct recruitment to the post of assistant professor, etc., that I can skip 3.2.0, Lordship. The minimum qualification required for the post of assistant professor, associate professor, professor, principals, assistant director, etc., will be those as prescribed by UGC in these regulations. 3.3, the minimum requirement of a good academic record, 55% or an equivalent grade in a point scale wherever grading system is followed at the master's level and qualifying in the national eligibility test or an accredited state level test shall remain for the appointment of assistant professors. I am now skipping 3.
So this is for assistant professor. We are concerned with principal.
Principal.
The 3.3.0 is for an assistant professor.
No, for principal, 3.2.0 also includes principal. 3.2.0, second line, third word.
Yes.
Principal is also included there.
But
Minimum.
all right. Okay.
So
Yes.
Then next page, Lordship, where the learned single judge went wrong, I would like to place 3.4.1. A relaxation of 5% may be provided at the graduate and master's level for the scheduled caste, scheduled tribe, differently able, physically and visually able, differently able categories for the purpose of eligibility. So 5% relaxation can be given to them.
The categories. It is a.
Then, and is the word. And for assessing good academic records during the direct recruitment of teaching positions. So this is number 1. The eligibility of 55% or an equivalent grade in a point scale wherever grading system is followed, and the relaxation of 5% of the categories mentioned above are permissible based only on the qualifying marks without including any grace mark procedure. So the qualifying mark is 55%. That should be without any grace mark procedure. The learned single just thought that in respect of giving relaxation of 5% also, this grace mark procedure is not included. That is where, in my humble submission, there is an error on the part of the learned single judge.
Right.
So there is no dilution of the eligibility criteria of 55%. That grace mark is totally excluded, unlike the school teachers case, which Lordship is saying. There is no such provision.
Let's see how this aspect has been dealt with.
Yes, Lordship. It starts from paragraph 20. It starts from 18, the quoting of the rules.
Quotation of the
Then,
regulation.
then Lordship will kindly come to paragraph 21.
Yes.
Page 194. It is not in dispute that the petitioner has been awarded 6 grace marks in his MA examination. Without the grace mark, he had obtained 434 marks out of 800. And with the grace mark, his total had become 440 marks, which is 55%. A perusal of the ordinance of the University of Pune provides that a candidate who passes in all the subjects and heads of passing in the examination without the benefit of other gracing or condonation rules and whose total mark falls short in securing second class, higher second class or first class by not more than 1% of the aggregate mark of that examination or 10 marks, whichever is less, shall be given the required. This is the statutory provisions of the Pune University, which is not applicable or which cannot prevail over the UGC. In tune of the provision of 6 marks was awarded to the petitioner. Paragraph 23.
no material has been placed before this court to show that the grant of grace mark is not in consonance with the rules and guidelines of professional statutory bodies like IICT, MCI, Bar Council, CCIM, etc., or that it runs counter to any UGC guidelines. Clause 3.4.1 of the UGC regulations 2010, on which reliance has been placed by so-and-so, caters to an entirely different situation.
Ms. Saikia, the learned single judge holds that 3.4.1 exclusively deals with the reserved category. For them, the 50% can't be accounted for by giving any grace marks, because that would tantamount to further relaxing the bar, lowering the bar below 50. That is the reason.
That is why, Lordship, I am saying that what this eligibility, the qualifying mark.
Entire 3.4.1 is in relation to the relaxation to
The first part,
No. Read the second part even. Eligibility marks of 55% for equivalent grade in a point scale and the relaxation of 5% to the categories mentioned above are permissible based only on the qualifying marks.
Now, the second paragraph, the eligibility of 55 marks. Now, why this 55 marks? It is for the general candidate. Second sentence. The eligibility mark of 55 marks or an equivalent grade in a point scale wherever grading is followed, and the relaxation of 5 marks to the categories mentioned above are permissible.
Yes.
And the relaxation of 5 marks to the categories mentioned above are permissible based only on the qualifying mark. So qualifying mark, there should not be any grace mark.
Yes.
Based on only the qualifying marks without including any grace marks procedure.
Yes.
So that 5% for relaxing to the SC, ST and other
You
categories.
can't go below that 5% by giving grace marks. Supposing a scheduled caste candidate secures 50% with 5%, 3% grace marks, then he will not be
He is
qualified.
not, he'll not be
Same
eligible.
way, if a general candidate secures 55% with grace marks, that will not be counted as a qualifying criteria. That is
Yes.
what your case is.
Yes, Lordship, that is my case.
Yes. Carry on.
Now, see, I'm going back to the judgment again, Lordship.
Yes. Now, single judge reads this entire 3.4.1 for the reserved categories only.
It is, yes, that is what the learned single. In my humble, there is a there is a division.
There is a division.
There is a division.
The provision runs in 2 parts.
2 parts.
Is in 2 compartments.
2 compartments, Lordship.
One is
2
where the
different events are
5%
contemplated.
5% relaxation is provided. And
Yes.
the second part says
Exactly.
that either with relaxation or in the unreserved category, the marks, minimum marks must be without any grace.
Without any grace mark procedure.
And further that would be fortified by the next 3.5.0.
Yes, Lord.
Wherein 5% relaxation is permissible to PhD holders.
Yes, Lord.
So,
This should not include any grace marks. Either 55 or 50, whatever the case. Deals with both
Classes. Yes.
Now, reading further, Lordship, paragraph 23, page 195. No material has been placed before this court to show that the grant of grace mark is not in consonance with the rules and guidelines of professional statutory, etc. Clause 3.4.1 of the UGC regulations 2010, on which reliance has been placed, caters to an entirely different situation. It prescribes a relaxation of 5% for the scheduled caste, scheduled tribe, and differently abled categories of candidates for the purpose of eligibility and for possessing good academic record. Thus, if 5% relaxation is provided, the eligibility marks for such a candidate would be 50. It is, however, made clear in clause 3.4.1 that in the event of grant of relaxation of 5%, 50% of mark that will be required to be obtained will have to be without the aid of
Yes.
Oh, sorry, sorry. Sorry, I was getting.
He gets excited, Lordship.
No, both of you have that propensity. Don't single him out. Introspective.
I have to follow his, say he's my senior, Lordship.
That's a good suggestion. And more particularly when you are both on the dais, that propensity increases. Yes, but it's
We are neighbors also, Lordship.
it's good to have fireworks sometimes. I really sincerely tell you, sometimes I miss that kind of
My lord,
assertiveness in the lawyers.
my lord, it shows the involvement in the case.
Yes, it does. It does. I really.
But we
frankly
are friendly
appreciate-
neighbors, Lord.
I frankly appreciate. I tell you, many a times I miss those days. Yes, a lawyer is supposed to be assertive. He is
And
fighting
Lordship
for his
has
client.
missed that forever. So, 3.5, in the event of grant of 5%, 50% of mark will have to be required to be obtained, will have to be without the aid of grace mark. Indirectly, 3.4.1 also recognizes that there is a practice of grant of grace mark. In Annamalai University, the Supreme Court laid down that relaxation cannot be granted in regards to basic things of necessity or conferment of a degree. It is not the case of the respondent that any relaxation was granted to the petitioner while master degree was conferred to him. So this is the finding of the learned single judge. Then paragraph 26. In view of above discussion, the submission advanced that 6 marks awarded to the petitioner by way of grace mark cannot be taken into consideration to work out the percentage of marks obtained in MA examination does not find favor of the court. Clause 5 of the UGC regulation 2009 provides that no university institution or deemed to be university and college institutions of national importance shall conduct MPhil through distance mode. Now coming to the requirements of the eligibility criteria, Lordship is pleased to come to the advertisement at page 32. Page 32.
Yes.
The guidelines, Roman 1, eligibility criteria, master degree with at least minimum 50% marks or equivalent grade wherever grading system is followed from a recognized university, that is the 50% requirement.
Yes.
And number 2, PhD degree in concerned relevant allied discipline in the institution concerned with evidence of published work and research guidance. We are not concerned with the PhD because he is having PhD.
He is having PhD.
But research guidance he is not having.
Then there is one question which crops up. If he is having PhD, Mr. Saikia,
Lordship.
please come to 3.5.0.
Yes.
Yes.
Then he automatically gets 5% relaxation.
5% relaxation, but without grace mark.
So 5%, there are 6 grace marks given to him.
6 grace marks.
So with 6 grace marks, he is having 55%. Remove the 6 grace marks, what would be the percentage?
No, that is not the intention of the.
Yes, that is
He is not
intention.
entitled.
Grace marks would bring him up to
He is
55.
he has to obtain his master's degree prior to 1991. That is the clause. Page 63, 3.5.0.
Yes.
A relaxation of 5% may be provided from 55 to 50% of the
Okay,
marks to
PhD
the
holder,
PhD
those two
who have obtained their master degrees prior to 19 September
but his
1991.
master's is subsequent.
Recent.
So this clause doesn't apply to him.
It is not applicable.
Yes, yes.
So He has to,
He has PhD, he is required to have 55%.
but
He
he has
doesn't
to
get
get his
relaxation.
PhD prior to 1991.
No, masters, not
Masters.
PhD, masters.
Masters, Lord.
So what is the date of his masters? Can we know?
Masters, Lordship, I can just,
Let us know. Okay.
this chart, can you lay the chart?
Now, he has done his higher secondary in 1996,
Yes, so
probably.
much later, Lordship.
So obviously,
Masters in 1996.
masters,
Masters.
where is it?
Masters in University of Pune, yes, 1996.
1990. So it's after 91
Yes.
in any event. So 3.50 doesn't come in his aid.
To his help.
To his aid, yes.
Maybe that was the reason it was never urged also.
This was never argued, yes. So next come to this, the PhD is there.
PhD, now
Yes.
guideship. Guideship is also mandatory.
Where is it?
That clause number 2, PhD and
With evidence.
research
of-
guidance.
Yes,
That research guidance, he has done research guidance of the undergraduate level. That is not recognized by UGC or any other university.
all right.
For
Where is
that, we have to look into that thing, the PhD and MPhil. Second here. Don't photo of them nine. If we look at the 2009 regulation of UGC, 2010 regulation.
Nine.
If I can keep on.
Mr. Chamwa is an expert on this, no? Yes. Read, Ms. Saikya.
Yes. A research guidance, Roman 3D says, if Lordship has got the same page.
No, he has given us the regulation 2009. You are reading where?
I'm just referring it.
This is 2009 we are having.
This is 2010 regulation.
Assistant principal, right? Research guidance.
Research guidance, it
Clause.
should be for MPhil and PhD. 3D. So it is not for undergraduate or, because there is no such, nobody does the research at graduate level or undergraduate level. So he is not fulfilling that criteria also. What the learned single just says, that it is not required.
Is not required.
It is not required.
Okay.
It starts the finding from paragraph 27. Clause 5 of the UGC regulations 2009 provides that no university, institution or deemed to be university and college institution of national importance. No, in my the judgment.
Yeah.
196, paragraph 27. Clause 5 of the UGC regulations 2009 provides that no university, institution or deemed to be university and college institution of national importance shall conduct MPhil PhD programs through distance mode. The eligibility criteria for MPhil PhD supervisor is total experience is 15 years of teaching, research, administration, universities and other institutions of higher education. It lays down a supervisor shall not have at any given point of time more than 8 PhD scholars and 5 MPhil scholars. Significantly, the UGC regulations 2009 does not use the word guide. It appears that some universities were hiring services of supervisors who did not happen to be regular teachers of the university or its affiliated PG colleges, institutes awarding MPhil PhD degrees. As a practice, was in violation of the UGC regulations.
That part, Ms. Saikya, wherein the aspect has been dealt with, that the
Yes.
guideship must be of postgraduate or PhD.
Yes, Lordship, paragraph 29, page 199. The certificate dated 1/2/2014 issued by Singhania University goes to show that in the said certificate, the petitioner has been certified to be an approved guide supervisor in MPhil PhD. By the letter dated 16/8/2015 of the director Vinayaka Missions University, Annexure F of the affidavit in opposition, the petitioner was recognized as MPhil PhD supervisor in sociology with effect from 16/8/2015. Thus, it appears that the word guide supervisor is used interchangeably. Apparently, such appointment as guide supervisor by the aforesaid two university is not in consonance with the University Grants Commission Regulation 2019-9. Letters dated 66/7/2015 and 4/9/2015 only reiterated, highlighted and emphasized that supervisor has to be a regular faculty member of the university or its affiliated PG colleges institution. It cannot be accepted that such transgression and violation should be taken note of only after the aforesaid letters were issued. The violation being of UGC Regulations 2009, any such certificate or of guideship after the aforesaid regulation of 2009 had come into being cannot be accepted as valid certificate, as acceptance of the same would amount to giving premium and encouragement to flouting laid down norms. The decision of Calcutta High Court, I'm skipping paragraph now 32. In clause 4.2.0, in respect of principle, it is not prescribed as in the case of professor that one of the requirement is experience of guiding candidates for research at doctorate level. What is prescribed in clause 4.2.0 is evidence of published work and research guidance. In the pleadings, the petitioner has brought on record evidence of published work and research work conducted under Krishnakanto Hendik Open University. Perusal of letter dated 6/7/2015 and 4/9/2015 go to show that only regular teachers of the universities and its affiliated PG colleges institutions can be supervisor. The number of PhD scholars and MPhil students under a supervisor at any point of time is limited to 8 PhD scholars and 5 MPhil scholars.
This one seems to be reasonable, Mr. Saikia. 4.2.0 doesn't specify that the research guidance should be of the postgraduate or the PhD candidates.
Yes, but
Whereas
the
for professors-
UGC regulation says it is for MPhil and PhD only.
For which post? Let's see.
Research.
Let's see.
Now, I am of the opinion that it is
Let us
impermissible.
see the guidance again. Guidelines. 63. Or not?
Yes.
Yeah, this one.
Category research and academic.
This is for which post?
This is for the post of principal.
Let's see, just.
As a general, this is the part of the UGC's guidelines and regulations. 2010 regulation, it is a part of it, Lordship.
We are reading.
That research guidance. What does it say? Research guidance should be for MPhil and PhD. There is no scope of any research guidance below these two levels of courses. Lordship will also see 3 candidates, 10 candidates, and 7. And for principal 4.2.0, Lordship, page 64. What do you think?
Saikia,
Lordship.
That's where 4.1.0 become relevant. Read 4.1.0 A subclause 2. When
A PhD is concerned, allied relevant disciplines in the institution concerned with evidence of published work and research guidance.
4. That's where the learned single just draws the distinction. Read 4.1.0 A subclause 2. When we are dealing with the professor, your guidelines make it clear that the research guidance must be of candidates at doctoral level. Whereas in principle, it doesn't make that particular specification.
Principal post is always above the professor.
No. You are mistaken, sir. What are you talking?
A professor can become principal.
Yeah, maybe, but you can't put across a proposal that the principal's post is above a professor.
Yes, Lordship. Now it is on rotation also.
Associate professor can also become a principal.
So when we say it is for principal, 4.2.0.
Yes.
It is for the post of principal.
Guidance, there is no such qualification that it has to be at the doctoral level only. So
because we have to read it with the 2010 regulation. This is a part of the regulation. That whatever I have placed, it is all under 2010 regulation.
Okay.
we have to read
Were
as
the
a,
2010 regulations brought to the notice of the learned single judge?
yes, Lordship.
Yes.
It was brought to the notice of the single judge, and on top of that, his research guideship are from two universities which are not recognized by UGC. This Singhania and the other one, Vinayaka. These are not recognized. And what they are saying that he has done it on ODL system.
All right.
ODL system is also
So
not
these are
permissible.
These are the two arguments. One, research guidance not of MPhil or PhD candidates.
That is number one.
And
And
secondly,
the documents
grace
which he has submitted, those documents also do not belong, were not issued by the institutions which are recognized.
Okay, let's get the first response to the aspect of grace marks. Let's hear them on that.
My lord, before I even respond to the 2 points which has been asked by my learned friend, first let Assam government clarify, my lord, whether they have adopted UGC guideline or not. Because in so many other litigations, my learned friend as Advocate General has appeared and made a submission that Assam government has not adopted UGC guideline. And because of that, my lord, many petitions were dismissed. Because according to us, UGC guidelines were not followed in those recruitment. But the stand of the state government is no, we have not adopted. I'm placing the judgment, my lord. 2022 5 GLT page 87.
Burning issue.
So many cases, my lord. And
We know.
coincidentally, I appeared in 2 such cases.
But we have decided in one case, Mr. Probably you are appearing that matter.
Yes, yes.
In that we have held.
Kokrajhar College.
Yes, Kokrajhar College. In that we have held that UGC guidelines are
Actually, my
applicable to
lord,
Assam.
No, till then, my lord,
Yes.
the Kalyani Motivanan judgment was holding the field. Where in Kalyani Motivanan, my lord, Honorable Supreme Court said that as far as central universities are concerned, it is binding.
Binding.
But as far as state universities are concerned, it will have to be adopted.
Adopted by.
Now, subsequently, there is a judgment of the Supreme Court, my lord. From that, the situation would be different.
All right. Justice M.R. Shah's judgment.
Yes, my
Yes.
My lord will kindly come to paragraph 5. The sentence starting with my lord, these I care learned Advocate General of Assam. on
What
the
do
other
you
hand.
have to say on this statement of yours?
Yes.
Lordship. Your stand in this court has been the Assam state has not adopted UGC guidelines.
That
You will
is
have-
one part.
That is the most important part then.
No.
Can you follow on to the UGC guidelines then?
We cannot, Lordship.
Can you take
If
two
that
different?
is the argument, then my argument is totally based on the advertisement eligibility criteria.
Yes, come to that, whether you have ousted him on that count. Whether you have ousted him on that count.
What we have said,
Your entire case is, edifice of your case is UGC guidelines.
UGC guidelines.
So, yeah.
Absolutely, Lordship.
Then all, if,
So far as the recruitment condition is concerned, Lordship, we cannot dilute that. We cannot dilute that.
Ms.
That being
Saikia,
the central legislation. There are a lot of other advisories in the UGC regulations of
no,
1956.
you can't make a distinction like that. This was also a case of selection.
Yes.
This was also a case of selection. Read this. You know, pass it on. Yes, the eligibility and selection both.
Yes, Lordship, I will place it, Lordship, because this was not the argument earlier. I have the counter argument here.
Yes, let's see. Let's. That Kokrajhar College, what was the name?
My lord, ki Brahma asile? Asharani Brahma.
Asharani Brahma.
Asharani.
Asharani Brahma judgment. Yes.
So far as eligibility criteria, Lordship, we have a OM where we have adopted that all the
Probably in Asharam Brahma, we have Asharani, we have dealt with that OM.
Because of the subsequent judgment of the
We have dealt with the OM.
Yes, yes,
Not,
yes.
not because of the judgment.
Yes.
We have dealt with the OM itself. Let's have that judgment.
we have adopted it. That particular area we have followed.
Ms. Chaudhary is coming to your aid only. Don't worry. He has argued that matter wherein we probably accepted his argument.
No, my lord.
No,
No.
it was against what you argued. And we don't recollect.
Anyway, my lord, on the other 2 points also, let me make
Other
my
points,
submission.
come to the other points because this
Yes.
will not,
Yes.
not survive in view of what we have
I
held in
think-
Asharam.
But first of all, my lord, the learned legal judge, if you lord
Yes.
kindly come to the impugned judgment.
Ms. Chaudhary,
My-
first satisfy us on the grace marks aspect.
Yes,
We are very, very clear. 3.4.1 has two parts.
yes.
Very clear that interpretation made by the learned single judge, that it only deals with reserved category candidates
My lord,
is not correct.
my lord will kindly come to 3.4.1 at page
Yes.
63.
Yes, please.
A relaxation of 5% may be provided at the graduate and master's level for the scheduled caste, scheduled tribe, differently able categories for the purpose of eligibility and for assessing good academic record during direct recruitment to the teaching position. The eligibility mark of.
So now
55
we have to pause. There's a
Yes.
break.
Yes,
And this is an entirely different scenario. First part says 5% relaxation. Then they say that applying relaxation and 55%, how they have to be achieved without any grace marks.
I'll invoke my lord usage generis.
Yes, do that, sir.
The
If
eligibility
that
mark,
was not so, Mr. Chaudhary, then there was no need to repeat 55% or mention 55% in this. They only would have said that this 5% relaxation that should not include any grace marks.
My lord,
No
my-
need to mention.
my
50.
initial reaction was also that, but having read it, anyway, my lord, let me
Yes,
try to
let's
satisfy.
read it.
Yes. The eligibility marks of 55% marks. And the relaxation of 5% to the categories mentioned above are permissible based on only the qualifying marks without including any grace mark procedure. Now, my lord, before lordship, even enters into, to find out the meaning of this. My lord, my humble submission is, my lord, supposing, my lord, for a particular post, certain percentage of marks in a particular qualification is prescribed.
Yes.
Now, my lord, whether with or without grace I have obtained that is irrelevant. Supposing, my lord, in a compartmental examination, a person passes his matriculation. Now, end of the day, he's a
You are
matriculation.
having a declare, you are a postgraduate, that's all right.
I'm a
But for
postgraduate.
being appointed a principal, they want a certain yardstick.
Exactly.
They want certain quality.
Yes.
That a person with a grace marks, we will not accept his 55% with grace marks.
It doesn't say so, my lord. With all respect, I'll submit, my lord. The eligibility mark. Eligibility mark by the person and the relaxation.
Yes. That element, so he will hold a teaching position. They said that he will only think like
My lord.
Yes.
Yes. My lord, in my humble submission, my lord, the meaning which has been given by the learned single judge is absolutely correct, my lord. Because though my lord, there is a full stop and thereafter again it has been started. In my humble submission, my lord, it has been done to reiterate what is there in the first part. Because it says to the categories mentioned above.
Sin is there, and six is guideline of
These are guidelines of year.
2010, my lord. Yes. My lord, my humble submission is, my lord, even though there is a full stop,
Yes.
it does not relate to any others, but it relates to, my lord, scheduled tribe and scheduled caste only. That would be evident from the later sentence, and the relaxation of 5% to the categories mentioned above are permissible.
Yes.
Based on only the qualifying marks without including any gate.
That is one way of interpreting, Mr. Chaudhary. We are not very satisfied about that.
No, my
To
lord,
our mind, they very fact.
if there are two views possible, my lord, the view accepted by the learned single
Except
judge.
for a better yardstick to be applied for appointment as a principal
No,
should
my,
be accepted.
no, my lord, I think this categorization in 3.4.1.
It can't be for the simple reason
Yes,
that you have given 5% relaxation.
yes. So that's why, my lord.
Just hold on.
Yes,
Hold on,
okay,
sir.
okay.
That is to a category which is reserved category. At every point of time, in every recruitment, every academic qualification, that is given. Now, if you don't give them the grace marks and give the grace marks to the general category candidate, situation would be, supposing the marks are out of 100. So general category candidate securing 49 and 6 marks of grace would be selected, whereas a scheduled caste category candidate having 50 marks would not be selected. So that situation can't be allowed to prevail.
My lord, well, that's one of the way of course, that's a way of looking in, my lord.
Yes.
My humble understanding of 3.4.1 is, my lord, we are
It is
already
only
giving you,
applicable to.
we are already giving you one relaxation
So
of
no further
5%.
relaxation.
No further.
Yes. All right.
That's perhaps the only way. And my lord, the learned single judge's view in this regard. Having regard to the, my lord, background, my lord, it can't be said to be not a plausible view. It's a view, my lord, in my humble
Very well.
submission is correct.
Okay.
So therefore, my lord, number one, to
Grace.
award grace mark, there must be statutory provision, which there is. It can be by of any executive fiat, my lord. Decision to award grace mark must be flow from some, my lord, legitimate source. And that is a statute. So learned single judge has dealt with this issue, my lord.
Grace marks, the university ordinances, the grace marks have been given.
Yes.
So you can't deprive him of the benefit.
And end of the day, I am a postgraduate with 55%. As far as the recruiting authority is concerned, my lord, it can't be their concern whether I passed with grace mark or not. Their concern should be whether I am 55%.
That scheme
Yes.
of their requiring the 55% clear marks fits in with the prior phase good academic record.
Yes.
So if a man gets 55%
Yes.
with grace marks,
Yes.
they say that it is not good academic record. That is a very logical reasoning.
And that could be. But end of the day, my lord, lordship is testing it in a statutory scheme.
Yes.
This, whether, my lord, in that view of the matter, whether 3.4.1 one can be given a meaning as has been given by the learned single judge, or, my lord, we are supposed to give another meaning.
Yes. Regarding second one. the
My lord,
distinction has been
regarding
drawn.
the second point, my lord,
The
please,
distinction has been
please
drawn.
come to, my lord, page number 63 for a moment.
Yes, 4.1.0 is the professor,
Yes.
wherein there is a specific qualification.
Yes,
Guiding
for
candidates
research at doctorate level.
doctoral level. Yes, we see that.
Then please come to page 64, my lord.
Therein there is no word.
Published and research guidance,
Yes.
and the same sentence has been lifted in the advertisement. So therefore, my lord, now the learned single judge has clearly there. In fact, my lord, I would say, my lord, the learned single judge has gone in deep details in dealing with each and every point. And first of all, my lord, the director's order is a cryptic order. He doesn't say why the governing body's resolution cannot be accepted. And that's why, my lord, kindly see, please come to, my lord.
They are agreeable to a remand,
Yes.
but without these observations.
My lord.
By assuming these findings, they are agreeable to the remand.
My lord, please come to page 90 for a moment. Paragraph 14.
90.
This is how the learned single judge proceeded in the matter, my lord.
90.
Why the page 190, my lord? Why the learned single judge undertook this detailed exercise? This is the para 14.
You're reading from
Page one. Oh, my lord, writ appeal number
para
284, para 14 of the judgment.
Yes.
190. Public authorities cannot play fast and loose with the powers vested in them the person to whose detriment orders are made are entitled to know the precise ground on which a particular course of action is taken and adopted by the public authority. Reasons are the soul of an order, and therefore recording of reasons for granting or not granting approval of a proposal for appointment of a principal of a college cannot be. My lord, this is the background in which the learned single judge proceeded, my lord. So my humble submission is, my lord, their basic two grounds. I don't think, my lord, the learned single judge has, dealt with in any manner which requires your lordship's interference, my lord. Both are plausible views, and it's a writ appeal is an appeal on principle, my lord. Merely because another view is possible. My humble submission is, lordships will not, my lord, substitute and that. That's my humble submission. Yes. My lord, in the other,
It's okay. Yes.
Hello, what had happened?
Why have you come in? Why has he come in appeal? Or
No, we are respondents, my lord.
there are two appeals. There are two appeals. What is
He is a writ petitioner. He is representing a writ.
Sharma. What is that appeal about? There are two writ appeals.
Yes, one filed by my learned friend, my lord.
No. They are both by the state.
Oh.
So you are arguing in the case of Amlendu Nag.
No,
Then Pratim Sharma.
Protein Sharma.
Okay. The issue of law and order is same in both the cases. It's like, yeah.
Yes, Lord.
Same. Yes.
His research guidance is.
Amlendu Nag is not there. Amlendu Nag will hear after lunch.
Yes.
All right.
The second case, my learned friends.
Amalendra Nag is lordship in respect of research guidance only, lordship.
Only on research guidance.
Only research guidance, lordship. Only research guidance.
We will see. At two.
Before your lordship rise, my lord, in that other Arunachal matter, they just to complicate matters, they have passed an order, my lord,
They didn't mention.
posting me somewhere else.
Essential.
Fresh order.
Fresh order. Tomorrow, yesterday, my lord.
Gathered by the.
During the hearing was going on. I'm just bringing it to lordship notice.
And any other interpretation will not only consider.
To be continued at Leparda. You represent Naimorina or?
And Narina, yes. Now I have been sent to Namsai. Earlier I was in my lord Kanubari.
He is the writ appellant.
Yes.
Yesterday.
And I have just brought it to your lordship's notice, my lord, subject to what view lordship takes.
We have to read, then we'll have to list the matter for mentioning again. List that matter for mentioning. It will be mentioned. They mentioned. To be mentioned at two. At two, we'll form the bench. At two.
My lord, deep lord.
Do you have any statement?
Yes.
Mr. LMD
Regarding the transfer matter.
No, regarding the matter
Yeah.
which we had taken up in the morning.
In my case, my lord.
Yes, in your
I have
case.
received one instruction, my lord.
Yes.
Exact instruction I read, my lord.
Yes,
There are 3 sanction posts
yes.
of DDSA at the Directorate of Secondary Education, but the government has attached 4 more DDSA as on need basis.
I am the fifth, my lord. And after that, one more has come. There are 6 now, not.
All right, we'll take up, and now we have a serious reservation on the manner in which your authorities are proceeding. The other case wherein we had reserved the order, they passed a fresh transfer order yesterday. If they think that they are above the High Court, they better rethink their own ideas. They'll draw the ire of the court. Any observations? Mr. Goswami?
In that case, my lord,
Yes.
I have been given telephonic instruction. It is being recalled, my lord. It will take just a few some time.
What business did your officers have to issue that transfer order? We are
Exactly, I
listing the
understand.
matter. We are listing the matter for to be mentioned on Monday.
On my.
And yes, and we will we'll definitely have our own
Well, I have sent
thoughts to
my,
record in that order.
my instructions I have sent to them immediately. Once that order was, copy was given to me, my lord, I told them, and it's being recalled. my lord.
If at all they want that the thing should peacefully proceed forward,
My lord,
they
could
have
done
to-
so many- absolutely, my thoughtless.
not only about this order, the other orders also.
Yeah.
Anyhow, we'll see that
My, on
Monday.
much obliged.
Yes.
Our matter, man, maybe hearing.
Your
it-
matter, yeah, we'll
Conclude.
take it up. Yes, we'll hear it after this one. Well, after this matter is over, we'll take up your matter.
Lordship, if the Pratim Sharma's case, I am for
Yes.
the writ petition.
Team Sharma, yes.
Writ petitioner, just to these 2 points of my learned senior friend has argued. I have to add just 1 or 2 points on that.
This issue is common to both the cases regarding that grace marks.
This is with this matter, Pratim Sharma, which already been argued.
Yes, this has been
The
argued. So
others, he is
there are twofold arguments in Pratim Sharma
Yes.
regarding the impure order. One is the view taken on the aspect of grace marks, and the second is on the aspect of
research guide.
research candidate.
So I'll
Yes.
just point out 2 things on this, your lordship. Your lordship will kindly take up the page 62, your lordship.
Yes.
This is the UGC guidelines, which have been already referred to. I'll just point out 2 things which have not been referred to.
Yes, please.
Yes.
Sure.
Here, your lordship will see page 62, 3.3.0. This is for assistant professor. I'm just saying that because I'll come to the point. The minimum requirement of a good academic record, 55% marks. This is
Comma.
for assistant,
Is comma.
comma,
there-
55% marks grade in a point scale wherever grading system is followed. The master's level qualifying and a net or accredited test, so and so shall remain for the appointment of assistant teacher. Now, your lordship will kindly turn to page 64. Now, let us go to the, which has not been shown, your lordship. Page 64 is, your lordship, 4.3.0.
Yes.
Here again, your lordship will see Roman serial number 1,
Associate professor.
associate professor.
Not
The
for
petitioner is an associate professor. That is why I am pointing
This,
it out.
this issue is regarding appointment on the post of principal.
Yes, I am coming to that.
Okay. Very good.
Why I am showing that, I will come and show that. Now, first line, good academic record with a PhD degree in the concerned allied relevant discipline. 2, a master's degree with at least 55% marks or equivalent grade in point scale wherever grading system is followed. So in associate professor as well as in assistant professor, 55% marks is mandatory. You have to have a good academic record. Now your lordship will kindly go up to 4.2.0, the principal. A master degree with at least 55% marks by a recognized university. Now here, your lordship, one thing goes, that is the good academic record. So here, why I'm trying to point out is that the petitioner was appointed as an assistant professor. Then he was appointed, it was in 2012, he became the associate professor. Now he has applied for the principal. The same rules, your lordship, this was the UGC regulations, have appointed him as an associate professor on these grounds, on 55 grace marks. In that case, they have not used the grace marks. Now they are saying you have, since you have a grace mark, we are not appointing you as principal. Then your lordship will go back to the grace mark part, that is page 3.63, 3.4.1. Why it is with regard to the reservation? Because the categories have been specified there. A relaxation of 4%, I'm not reading again and again, your lordship, this has been read twice. The second part which your lordship was finding it, the eligibility marks of 55% marks and the relaxation of 5% to the categories mentioned above. The categories mentioned are what? Scheduled caste, scheduled tribe, differently able, physical and physically weak. This is the reason, your lordship. That is what I want to point out. This is the reason the grace marks are not applicable with regard to the petition. Here.
एक जगह रिलैक्सेशन दे दिया दूसरा रिलैक्सेशन yes right.
Are you having the TET judgment, TET judgment?
Which
Apex court? That grace giving this mark in 50%.
Relaxation can be
Relaxation
permissible only in one part.
Yes.
It can't be duplicate.
Yes.
So if you give relaxation of 5%, then you can't have a further relaxation of grace marks.
Yes,
That is what they argue.
That is
the
that,
idea.
so that is why here he has not get that 5%.
Hmm.
He has got the grace. This is what I tried to point.
Hmm.
This is second part with regard to your lordship research guidance.
4.1, yes. नहीं, ठीक है, you're right, you're right. ये हो गया खत्म, उधर master degree ले लिया उसने. Yes, yes.
So your
Yes.
lordship, two things are not there in the principle. That is good academic record. And second part, which your lordship is research guidance. Here the research guidance does not say it's a published work. Again, your lordship will kindly see the associate professor, the next one down below, 4.3.0. Here your lordship 4, serial number 4. Contribution to educational innovation, design of new curricula and courses and technology mediated teaching learning process with evidence of having guided doctoral candidates and research guides. So here also it has been specifically mentioned, but in the case of principle, it has not been mentioned. So these are the two distinctions that I'd like to point out in these two cases. Basically, this is rest my learned senior friend has already argued.
Yes.
And
he has already been appointed as an associate professor earlier.
yes, he's an associate professor from 2012.
Okay, okay.
And your lordship, and one more thing, your lordship.
Yes, master's degree, associate. Yes. Yes.
In fact, I just one point, this is not relevant, but I'm just pointing it out. From the 2018 UGC regulation, the research guidance has already been, it is taken away. So now it is not at all required. You're just pointing it. That's it.
Okay.
So for his appointment as.
My lord, in fact, the Assam government has also issued circular where this guide sheet is no longer required. It effects from 2019.
Yes.
His appointment initially was as assistant professor. That was in 1996. And 2012, in all probability, he was promoted. So he will not come under the eligibility criteria. And if it has been done wrongly, lordship,
No, that is
that
not
will
your
not give
case.
him any right.
That is not your case, sir.
That is not
That
our
is-
case.
That is appointment as
That
an
is that
associate. That is not your case. That is appointment as an associate professor is questionable. There's no case
That
of
is
any
not
party.
the- only because he is arguing, that is
So
why I'm
he-
responding.
That is, it is a fact on record that he sought selection
In for
as
the
a
post of
principal
principal.
on the basis. Ms. Saikia, come to 4.2.3. Who can apply? 2.0.3. Page 64. Who can
Yes,
apply?
a minimum of 8 years, that one lordship.
No. Page 64, 4.2.0.
Associate professor.
Associate professor.
Associate professor,
So
professor. with a-
only either of these two categories can only apply.
Yes,
So
Lord.
he is an associate professor, no dispute.
No.
You have not ousted him on this ground that he is not an associate professor.
We did not went to that extent, Lord.
So, yeah, that means that he is an associate professor.
He's an associate.
Yes, then associate professor can only be a person who has a good academic record. That is again 4.3.0.
Lordship.
And the third part, this research students, doctoral candidate, associate professor, again, there is a catch that associate professor must have had contribution to educational innovation and having guided doctoral candidates and research students.
Yes.
So if he is an associate professor, he satisfy all these three conditions.
It is a fresh selection, direct recruitment, the
Yes.
principal post. If some college has wrongly done it and it was wrongly approved at some point of time, that will not, with elapse of time, will not rectify the eligibility criteria, allow him to participate for the post.
All right. Okay, we understand very well.
So that was not the case before a learned single judge, and it is not the case here also, but now they have argued. But I would like to clarify on the point of research guideship.
Yes.
So research guideship, there are different types of requirement under this UGC regulations of 2010.
Yes.
if Lordship is pleased to look at 4.1.0 professor, Roman 2, who can be a professor? A person with minimum of 10 years of teaching experience in university, college, or experience in research or university level, national level institutions, industries, including experience of guiding candidates for research at doctorate level. This is one way of their argument that for the post of professor, we have specifically said that the person must have research experience at doctorate level. This is the criteria because the post of professor also requires 10 years of teaching experience, and that teaching experience must include guiding candidates for research at doctorate level. And if we come to the next page, that for the post of principal, Roman 2 says a PhD degree in concerned allied relevant subject in the institution concerned with evidence of published work and research guidance. And the associate professor or professor must have 15 years of teaching experience. Roman 3. In professor's post, 10 years experience, which must include a person having guiding the research scholars at doctorate level. And so far as the next level at principal post, Lordship, it is the general said that he must have some experience or evidence for research guidance.
Published work and research guidance.
Yes, now research guidance for the post of principal, it should be very specific. That is, he must have the research guiding experience at the doctorate level. But in case of principal,
it is not there.
There is no specific requirement that it should be at the level of doctorate level.
Yes.
Here, there are two options are available. One is the MPhil and the other one is PhD. Two options are available because we have to look it from the perspective of the UGC regulations, because UGC regulations contemplates only two types of research guidance. There is no third option.
Then what was the reason for not specifically mentioning it in these qualifications? Any
Because
justification?
we have to read it with the UGC regulations because the eligibility
It's like
criteria we have adopted.
They have created a different class when associate professor and professor is concerned. They have specified that it has to be at the doctoral level.
Doctorate level.
Doctoral level.
Experience part.
Whereas in the
The
principal,
experience part, the 10 years experience must include the experience of having
and for
research
a
guiding at
principal, for a principal, they have given out
15
higher
years experience.
15 years experience. So
15
they
years
have, they
experience.
have increased the experience.
Exactly.
But they have left out the research guidance.
Yes,
to a
research
doctoral
guidance.
level.
We have to understand it because there is no such a third option. The two options which are available under the regulations. I'll place the regulations now.
Here, the regulations you have given.
Yes,
You already.
the regulations clearly says there is MPhil level guidance is possible or MPhil level, PhD level guidance is possible.
Yes.
There is no other guidance, research guidance at the level of any other level of education
Yes.
as per the norms. Now, who can be a research scholar, a research guide? Page 106, Lordship, for a moment. Category 3, it starts at page 105.
Yes.
Category 3 says research and academic contribution. Brief explanation. Based on the teacher's assessment, API scores are proposed for research and academic contribution. The minimum API score required by teachers from this category is different from different levels of promotion and between university and colleges. The self-assessment score will be based on variable criteria and to be finalized by the screening selection committee. Now, the first criteria is there. The second criteria is Roman 3C, research projects. What will compose the research projects? These are detailed there. Roman 3, capital D. Research guidance.
API. Yes.
Research guidance have only two categories, MPhil and PhD. There is no third category here.
What is this table? What is this table indicated?
This table
For
indicates
what
the category
purpose
of
is this?
research and academic contribution
For what purpose?
for
is
assessment of the various
APIs. So we are not dealing with APIs, sir.
We
We
are
are
not-
dealing with recruitment for professor, for which there is a separate section in the guidelines itself.
If that we have to follow certain principles.
Yes, we have to follow certain principles. We have to apply a
Yes,
set of regulations which are applicable
Yes.
to a particular situation, which
yes.
has been highlighted in the very
Now,
beginning of the
let them
chapter.
say at what level they are doing the research guidance part.
Yes, please.
They have understood it rightly, Lordship. Now they are arguing differently. That is a different story. But they have understood it very rightly that they must have research guidance experience in MPhil and PhD. And for that purpose, they have submitted 2 certificates. That's 2 certificates which they have relied upon. I would like to place now. Those 2 certificates, Lordship will kindly come to page 171. They understood it that there are
Yes.
page 171, the certificate which they have furnished to us.
Yes.
7 February 2014, Singhania University established under University Grants Commission's provision of 2F. Sri Dr. Pratim Sharma, Associate Professor, Department of English, Dikhomu College, Sibsagar, is approved guide of this university for MPhil and PhD in English. So he knew that this is possible only in MPhil level and PhD level. And next certificate also, he furnished another certificate, Vinayaka Missions University.
He is also desirous of getting a particular API score, sir, for which this research
No,
guidance.
these are the documents he submitted for the selection purpose.
Okay. Very well.
Now here, this is from Tamil Nadu. I am pleased to inform you that the authority concerned of Vinayaka Mission University has approved and recognized you as MPhil/PhD guide supervisor in sociology with effect from 16/8/2015. So he furnished another certificate. Now we have to place what is 2009 regulation of UGC. Who can be a supervisor or a guide? If Lordship is pleased to take this, the UGC minimum standard and procedure for award of MPhil PhD degree regulation 2009.
Yes.
In exercise of power conferred under so and so, the University Grants Commission makes the following regulations. Title: the regulations will be called University Grants Commission Minimum Standard and Procedure for Award of MPhil PhD degrees.
MPhil and PhD.
I am coming to
Enrolling into MPhil and PhD. Very well. Yes.
for all universities, institutions deemed to be universities and colleges, institution of national importance shall be eligible for conducting MPhil and PhD programs. Notwithstanding anything contained in these regulations or any other rule or regulation for the time being in force.
Why are we reading this?
Yes, Lord, because he has done it on distance mode, which is not permissible under the regulation.
2009, he did it in the year.
No, he did it in 2014 and 2016, 15.
What? Sir, this is for enrollment into a fresh
No,
course of
Lordship,
MPhil.
it is regarding the supervisor. Who can be a supervisor? Lordship, will kindly bear me with for 1 minute.
Will we read
Number 4.
Will we read the header of this regulation?
That is, but inside that, Lordship, there are a lot of other materials also.
Okay, very well.
Number 4. All universities, institutions deemed to be universities and college institutions of national importance shall be eligible for conducting MPhil and PhD programs. Notwithstanding anything contained in these regulations or any other rule or regulations for the time being in force, no university, institution deemed to be university or college institution of national importance shall conduct MPhil, PhD programs through distance education mode. Next is eligibility criteria for MPhil, PhD supervisor. That comes under for this purpose. Next, all universities, institutions deemed to be universities, colleges, etc., shall lay down the criteria for the faculty of recognized as research supervisor, both for MPhil and PhD programs. All universities, institutions, etc., shall lay down and decide on annual basis a predetermined and manageable number of MPhil and doctoral students, depending on the number of available eligible faculty supervisors. So what he is becoming, Lordship, as a guide, he is a supervisor. So to be a supervisor, he has to fulfill all these criteria, and the institution must not conduct any distance mode PhD and MPhil programs. There's a direct bar. What he has done it through distance education mode. And on top of this, the said two universities are not recognized university under UGC. So all these documents have no meaning, Lordship, because these are not recognized in institutions, number one, and he does not fulfill the criteria under this particular regulation of 2009.
Okay.
In 2012, the state of Assam has also issued a notification to that effect. So he cannot become a research guide. 170. 170. Yes. Now, Lordship will kindly come to page 170 of the memo of appeal. Dated 9 July 2000.
This will all come into picture only if we accept your argument that he has to have a research guide. He had to be a research guide of MPhil or PhD candidate.
Because the University Grants Commission do not recognize any other score, any other mode of guideship.
Okay, very well.
I have the UGC's affidavit also, which I'll place.
We'll read.
9 July 2012, functioning of off-campus study centers opened by the universities out of the territorial jurisdiction.
What are you reading, sir?
Page 170.
Yes.
Government of Assam is aware on the issue that off-campus centers, study centers, and centers operating through franchises are opened in this state by the university outside the territorial jurisdiction of their universities. However, in view of the decision of the Honorable Supreme Court in Yashpal's case, no university can start off-campus centers beyond their territorial jurisdiction of the concerned university as specified. Recently, it has been reported that there are a large number of off-campus centers of other Indian universities which are functioning in Assam. In spite of Honorable Supreme Court judgment against such off-campus centers, study centers, in view of aforesaid Supreme Court judgment and which that such off-campus centers which are existing are in violation of Supreme Court's order, the following directions shall come into effect immediately. The concerned universities shall ensure that no off-campus center, study center, and the center operating through franchises are opened by the university outside their specific territorial jurisdiction in view of the judgment of Supreme Yashpal. In case of university has already started off-campus study centers violating the Supreme Court order and the center are operating through franchise in the state, the same shall be closed immediately. No distance education program shall be started without prior approval of the Education Council, the regulatory body for distance education program. The Director of Higher Education Assam and the Director of Technical Education Assam strictly ensure that such off-campus study centers which are in existence in the state in violation of the Honorable Supreme Court's order do not function, and the government of Assam will not recognize any degree, diploma acquired by students who complete such degree diplomas from such off-campus centers. So what he has done, Lordship, he was doing his research work or his guideship through some study centers and procured those certificates. So those are not acceptable in view of the law laid down by the Supreme Court, the regulations of 2009, the UGC regulation, and subsequently fortified by this notification of the state government. As a result, a lot of other university degrees, Lordship, were all removed from their services in Assam. And recently also another BA degree things are coming up from West Bengal. Those are also under scrutiny now. So his certificate at page 171, Lordship may once more be pleased to look at. This was of 2014.
Yes.
From Singhania University. That is in English for MPhil and PhD, and 172 for sociology. This is not the subject. So he acquired these two certificates, and also his other qualification of administration things, Lordship, he has given wrong things. According to him, he was in charge of certain institutions at some point of time, but we have verified, and page 173 onwards, he said that he is the coordinator, but coordinators' names are showing differently.
Yes.
That Ranjit Kumar Borua, actually the petitioner is Pritam Sharma. So during this period, he claimed that he was the coordinator, but the actual record reveals somebody else's name is appeared, Ranjit Kumar Borua, in all these years. Page 173 to 177. So these are misrepresentation issues also. So my humble submission is, Lordship, yes. And regarding guideship, there is a division bench judgment of this honorable court also. 2016 1 GLT from Manipur, it came, page 74.
Yes.
No, it is not Guwahati High Court, it is Manipur High Court.
Doesn't matter. Yes.
Paragraph 24, Lordship. May I read it? The petitioners have raised another ground relating to the experience in research guidance. It has been contended by the petitioner that in UGC regulations 2009, issued on 1/6/2009, it has been provided that notwithstanding anything contained in these regulations or any other rule or regulations for the time being in force, no university, institution, deemed university, college, institution of national importance shall conduct MPhil, PhD programs through distance education mode. It has been submitted that the private respondents, Dr. A. Nabachandra Singh, was declared as research guide by the CMG University in Shillong, though he was never part of the faculty of the said university. The said university is a private university which has been embroiled in various controversies, and any PhD degree awarded by the university is of doubtful nature. That apart, CMG University was allowed to conduct MPhil PhD programs in regular mode only in its main campus in Shillong, Meghalaya. And as such, in terms of the provisions of the UGC regulations 2009, as mentioned above, the PhD cannot be awarded unless the same is conducted in the main campus of Shillong. The petitioner contended that the respondent number 43 so-and-so was not a faculty member of the CMJ University, as he was serving as an associate professor in Thaubal College, Manipur on regular basis. Hence, he could not have validly guided any PhD student under the CMJ University in Shillong, as any PhD program conducted through distance education is prohibited by the UGC regulations of 2009. For similar reasons, the research experience of the respondent number 4 obtained with reference to other universities outside the state of Manipur cannot be taken into account. Therefore, the petitioner contend that on this score, the alleged experience of research guidance through distance mode being impermissible cannot be counted in his API score in terms of the UGC regulations.
Yes.
It is further contended that, I'm skipping that. 26, then 26. We are not able to accept the contention of the respondent. The argument advanced by the private respondent that the requirement of research guidance of a candidate relates to the guidance received by the candidate concerned under a guide in course of obtaining the PhD degree lies in the face of the rules. The essential qualification for appointment of the post of principal as per the advertisement and UGC norms is the possession of PhD degree in the concerned allied relevant subject in the institution concerned, with evidence of public work and research guidance. Same wordings we are using here also.
Yes.
So this is ultimately not permitted by the Honorable Court. What the rules therefore require is that a candidate should be PhD degree in the concerned discipline. There must be evidence of the candidate having published work and research guidance. In other words, the candidate must not only be a doctorate in the concerned discipline, but must have.
The issue involved in this matter, Mr. Saikia, was that whether the experience gained by the candidate himself doing research while acquiring the PhD qualification is the research which is covered under the qualification.
It is not like so. It is a research guidance. The issue is research guidance here.
That is what we are saying. The court said that the candidates claimed that what research they did while acquiring PhD, that should be considered to be the research guidance, which the court negated.
No, it is not like that, Lord. It is, he was working in a college in Manipur, and he said he was a research guide of a college in Shillong. He has applied for the same post.
Please come to page 113. Therefore, is 113, the second last page, third last page of the judgment.
Yes, Lordship, page 113.
Yes, come to the
Yes.
second last para, last 5 lines. Therefore,
The only meaningful construction that would be evidence of the research guidance relates to an experience which
which
is
is
not
not an integral part of the PhD degree
in the
acquired by the candidate himself. So he has to be a research guide of someone else. That is, there is no dispute about that. This judgment is in no manner relevant to the present.
ultimately what the honorable court says that the certificate he furnished from CMJ is not acceptable to be a.
Because that was a research which he himself did. He has to guide someone. That is the controversy.
If we look at from that perspective also, the thing is same. Because he have to conduct.
Guide someone. That's right. Your case is that the persons he guides should be either undergoing MPhil course or they should be doing.
That is number one.
Yes.
And number two, where he is doing. Not in the off campus.
Okay.
What? In the instant case, this gentleman, the writ petitioner did not went to Rajasthan or to Chennai to be a research guide.
Can we come to page number
certificate yes.
page number 112. Then come to
Of the judgment, Lordship.
no, the paper books. 112, 113. Then come to 114.
These documents, Lordship, this is for the administrative part. This is
He is the research guide of these people, particular candidates, sir.
Yes, Lordship. The thing is that these are not MPhil course or PhD course.
That argument you have noted, that we have noted that argument. We'll deal with.
Lordship, number one. Number two, may I read this certificate? Let us read this certificate.
You have not doubted these certificates, sir. Why do we need to go into the?
No, the certificate, suppose this is not required under the advertisement.
That argument, we'll deal with that argument, sir. But you are saying that they are all having certificates of universities which were off campus. These are the certificates of university in Assam.
In what course, Lordship?
Oh, that argument, Mr. Sakia, don't please.
No.
Don't be.
One thing is very clear.
Yes.
Whether our curriculum of BSc, BA or any other undergraduate program, is there any scope of any research work?
Yes, why not? Why not? Nowadays, even fresh students in NLUs, they are doing research. First year students.
This is a dissertation, Lordship. That is a different. May I read this? What exactly this certificate reads?
You have not rejected these certificates on the ground that they do not constitute research. So Mr. Saika will not substitute.
No. Who has
Isn't
given
it
this
of the authority?
certificate? Who has issued this certificate? The person himself.
Study center.
It's a self-given certificate.
Page 112.
Page 112. Preterms to protest for the petitioner himself issued a certificate in his own favor.
Page 119, please. Page 117. Page 114.
This is what? Analysis report has been prepared by graduate student of mass communication so and so. This is it is not a research work. This is a project work.
The authorities have not rejected these papers on the ground that these are
These
not
papers,
research.
the authority did not went up to this level. When he did not qualify to
that is
get
their headache.
55%, he is out. Number one.
That is their headache, sir.
Then number two, we want research work or
will.
guidance work at a particular level under the
That you have said,
regulations.
sir, you have said that dozen
Yes.
times.
But
We
I'm continuing.
try to understand
Then let
as
me stop
best,
it.
to the best of our ability.
No, then I have stopping, Lordship. My submission is over.
Very well. Okay. Yes.
I have
Okay.
two Rajasthan High Court judgments also.
Yes.
I will not read it. Lordship,
Please
maybe
pass
please
it.
to have a look.
Please pass it.
These are not their arguments. These were not their arguments at any point of time.
All right. Arguments heard. Judgment. Next case. Amlendu Nag. Yes. Same argument.
Same issue.
No difference.
Same, my lord, only the name of the college and the date of advertisement will be different one, otherwise. As regards the research, there is no, my lord, grace mark issue.
Mr. Wa, this, you will have to go give a copy of the relevant part of these guidelines, or we can keep it. All right.
Public.
Yes, please. Yes, Itanagar part.
Item 5.
Mr. Mozumdar, we'd like to have their affidavit on this argument. Yes. We'll take note of your submission and ask them to file an affidavit.
My lord, let him file the affidavit. my
No,
lord.
no, we are recording his statement.
I have get this information from the director, my lord.
We are recording his statement. You have to respond.
Yes, sir.
During the course of submissions, Mr. Mazumdar pointed out that there are only 3 sanctioned posts of deputy director, education,
Secondary, deputy director of secondary education. Of secondary education.
of secondary education in the
Itanagar.
Itanagar,
Office of the
in the office
director.
of the director of secondary education, Itanagar,
My lord.
post of 3 officers are already working on these 3 sanctioned posts. With the transfer of the appellant to the said post, there will be 5 officers working against 3 sanctioned posts in the office of the director of secondary education, Itanagar. That is your submission.
As in today, there are 6, one more.
There will be 6 officers. Mr. Additional Secretary General, Mr. NNB Chaudhary is directed to submit an explanation of the Director of Secondary Education, Itanagar, to this pertinent submission of Mr. Mazumdar, list on 1st August. Heard in part of Monday.
Can it be, my lord, second
Monday,
August?
31st, list on 31st for further hearing. Heard in part, list on 31st.
31st, my lord. I need.
First August. 1st August.
A copy of the.
The other matter also will then list on 1st for mentioning. Don't list it on 31st.
A copy of the order may be served.
Copy of the order shall be visibly uploaded right now in 15 minutes. Don't worry. Get a copy.
Deep.
Always for us examination. Yes. But Mr. Das, we are really at a loss to understand what is happening in Arunachal Pradesh.
This is like
Sad state of affairs.
this is my lord, what to say, my lord, this is.
The other matter which in which I was compelled to take. The other matter in which I was compelled to take suo moto. Nobody is waking up.
And all, my lord, this is, I am defending like that. Note 143, I have seen all ministers, some MLAs, some panchayat leaders, all note 143 kindly say. Note
including the production of documents, etc., my lord. My lord, however, the learned single judge, while deciding the case, did not went into the merits of the case. On the very first day, my lord, the matter was dismissed by observing that you have an alternative remedy available before the adjudicating authority. So you basically put your grievances before the adjudicating authority, my lord. So, my lord, in the meanwhile, my lord, we approach the adjudicating authority, my lord. Now, at the same time, my lord, we also approach this honorable court by filing an appeal, my lord. Now, in this meanwhile, my lord, when the matter was pursued before the adjudicating authority, the judgment of the honorable apex court came into.
Okay.
My lord, may I just give a copy of the
What is
judgment?
the adjudicating authority done?
Yes, ma'am. They have, my lord, adjudicating authority has basically, my lord, in the earlier stage, basically confirmed my confiscation. But in the appeal that we have approached, my lord, appellate authority in the light of the current judgment has allowed our appeal. So virtually this appeal becomes infructuous, my lord.
Counsel, Mr.
H.
Student submits that during pendency of this writ appeal, the appellants approached the adjudicating authority which confirmed the order of confiscation of the property of the appellant. But thereafter, an appeal was filed.
But this is the appeal, my lord.
Which has been accepted by the appellate tribunal under SAFEMA in light of the judgment rendered by Honorable the Supreme Court in the case of Union of India and another versus Ganpati Dilcom Private Limited, by the order dated 7/12/22. He has placed the order dated 7/12/22.
Yes, my lord.
The order of confiscation has been set aside. Then council thus submits that the and the proceedings initiated and as a consequence, the orders of the adjudicating authority confirming the action of the initiating officer has been interfered and forced. Then council thus submit has placed the said order for perusal of the court, and the same is taken on record
My lord.
in view of the fact that the proceedings initiated against the appellant have been quashed, nothing survived for consideration of this court in this intra-court rate appeal, which is disposed of as infructuous.
My lord, I'm highly obliged, my lord, deeply obliged.
Passed over item number 7.
What is the matter, Mr.?
By this petition lordship, one of the amendment of the Assam government was challenged lordship.
Execution more than issue notice of importance. Step for service be taken in 3 days. 3 notified 4 days.
Is it returnable?
Returnable in 3 days. Already. That's the service.
Obliged.